Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. Don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Hello, we're back. Yes, we're back. We don't often get an early day to get to do something unique and fun, i.e., deep dives into documents. We're going to be doing a document live this afternoon. Yep, we are. I'm going to give you all a minute. I'm going to go ahead and start reading a little bit and telling you a little bit about this case. This is the Arkansas versus Spencer. Aaron Spencer Supreme Court decision. Welcome in, everybody. Today we are diving straight into the Supreme Court decision on Aaron Spencer and the ruling that lands at the moment that could be not more than maybe, explosive. Because while this case has been moving through the courts, Aaron Spencer has been running for judge. Yes, for Strummer's seat, the same judicial seat connected to the very system now ruling in his case. Hello, June. Am I correct on that, Miss June? Correct me if I'm wrong before I go any further. Am I right about that? He is running for judge. And he's brought up on red room charges. At the same time, y'all, the ruling, what we're going to be talking about today is anyway, sorry, I got off on my tangent. Yes, the same judicial seat, the same judicial connection, everything in the system that's going to rule in his case. The timing, man, the legal implications, it's all a storm in and of itself. And today we're not just talking about headlines. We're reading the entire Supreme Court opinion and we're breaking down exactly what the justices have decided, why they decided it, and what this means for Spencer's future, both legally and politically. If you're watching live, settle in. You're catching this on replay, use the timestamps. We'll try and get it timestamped with this, and it's a big one. So let's get into the decision, okay? One of the things that's going to be brought out really quick, and I want to explain what it is before we get into it, is a writ of certiorari. I can't say this. Certiorari. So certiorari, it's spelt kind of interesting. It's CERTIORARI. It's one of those legal terms I just can't say. It's term. It sounds intimidating, but it's actually pretty straightforward once you break it down. Here's the clean courtroom version of this. A writ of certiorari is a writ that orders from a higher court telling a lower court, I know my Miss June was going to get it for me. He's running for Lonoke County Sheriff while facing the charges. Yes. The sheriff. I'm sorry. He's running for sheriff, not judge. Thank you so much. I knew it was something. He's running for sheriff in the same county that he's charged in. Thank you so much for getting it straight. Anyway, what this writ does is it compels the lower court to send up records of the case to a higher court can review it. It is essentially a higher court saying, we're taking a look at this one, boo. Okay, so that's what this is, because it's going to be brought up a couple of times. And I personally rather just go ahead and tell you what it is instead of us going over it 4 or 5 times. Okay, he's running for sheriff. I got the sheriff. I got that in my head. I'm sorry. It's a day. All right, let's get into it. Let's get into it. All right, here we go. Here is the Circuit Court of Lonoke. Is that how you say it? County, Arkansas, 23rd Judicial District, 1st Division. Redrum, 2, class felony. State of Arkansas versus Aaron David Spencer, the defendant. I, Chuck Graham, I got to do it in front of me. I got to do this as prosecuting attorney within the 23rd Judicial District of the state of Arkansas, which consists of Lonoke County, in the name of and thereby the authority of the state of Arkansas, on the information accused the defendant of a crime of Redrum 2 and Class A felony in violation of the ACA cited 5-10-103, a felony from which with firearm in violation of AC 16-9D-120 commit to as the follows. The state of Arkansas alleges on or about October 8th of 2024, Lonoke County, Arkansas, the defendant did knowingly cause the death of another person under circumstances manifesting extreme indifference to the value of a human life, Class A felony, in violation of the ACA cited 5-10-103, and to wit, Michael Falser against the peace of dignity in the United States. Enhancement. Any person convicted of any offenses classified by law of this state as a felony, whom employed any firearm of any character as a means of committing or escaping from felony, in the discretion of the sentencing court, may be subject to an additional period of confinement in the state penitentiary for a period not to exceed 15 years in violation of the ACA 16-90-120, signed by Chuck Graham, prosecuting attorney and or deputy. Yep. So let me get the next one up. Get this one down. Get this one up. Da-da-da. 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 Yep. Yoo-hoo! It is working. All right. So this here is the Supreme Court respondent. So we're going to just go through it. I've not been able to go. I'm literally going to go through this line by line with you for the first time. And here we go. Aaron Spencer. I'm using my new glasses, so hopefully I don't have to look sideways all day. Let me see if I can make this bigger and not impede. See if I can make this bigger without impeding too much on the document itself. Let me see what I can do. Give me a second. June, or whoever's on, Angela and or June, let me know if this is okay. I think it'll keep me out of it. Yeah, that works. Aaron Spencer shot and killed Michael Falsler. Spencer versus State 2025, Arkansas 91 at 2 cited. The state charged Spencer with second-degree redrum and is seeking an enhanced sentence for the use of firearm in commission of an offense. Spencer's trial is set for Monday, January 26th of 26. It's coming up, y'all. Spencer has petitioned the court for a writ of cessatory You know what that was? I just went over it. He asked the court to, one, vacate the circuit court's order setting a courtroom capacity for trial. First, he wants them to limit the number of people that can be in the courtroom. And he wants, I'm trying to do this without looking, exercise its let me do that. Superintending authority to remove Circuit Court Judge Barbara Elmore from the case. That's the biggest part right here. He wants to have this judge removed from the case. Removed. Bye-bye. So let's see why. And let's see if he won. The court should deny his petition for two adequate and independent reasons. First, because Spencer has an adequate remedy by appeal. Certiorari, whatever, is not warranted. Sorry, guys, I'm really bad with that word. I even looked it up. It's spelled S-U. It wants me to say certiorari. Certiorari. Okay, certiorari. There it is. I got it. Second, Spencer's assertion of the constitutional violations and implicability on the part of the trial judge are not supported by the record. Got to find the spot. Before Spencer has an adequate remedy by appeal, he is not entitled to a certiorari. The first requirement for granting a writ of certiorari is not order adequate remedy exists, but for the writ of certiorari, Spencer's petition fails to meet this basic requirement. Spencer makes two claims. The first claim is the circuit court order setting a courtroom capacity violates his right to a public trial under the Arkansas and United States Constitution. So the judge wanted to limit the number of people that could be in the courtroom. She was adamant about that. I see. Hold on. The circuit judge should be removed. Both claims can be adequately addressed in the direct appeal. Holding that the defendant was deprived of his constitutional right to a public trial and reversing and remanding for a new trial. So he was being denied the right to have the public attend his trial, thus violating his rights. Holding that the issue of the trial judge's alleged bias is not proper for a petition for prohibition, mandamus, or certiorari because the petitioner had or has an adequate remedy, namely an appeal, to challenge the trial court's denial of its motion to recuse. Well, okay, so let's talk about that as far as I know. Once again, I am not a lawyer, but I'm a criminal justice major. So the court, the one side saying that this judge is biased. She has done everything she can to block my rights to having an open courtroom and yada, yada, yada. And she is not willing to recuse herself. Then they take it up to the Supreme Court. The opposing side is saying, oh, he has a way out. He can appeal it after the fact. And they're like, no, boo, this is not how this works. So we got the dueling sides on this topic. In all honesty, I think if I think the Supreme Court should remove the judge if she's doing that, in my humble opinion. Hello, everyone. Thank you so much for joining. Spencer, now here's the thing. Spencer's running for sheriff. He's under all of that scrutiny and he's running for sheriff and he's winning. Go figure. Hold on. Allergies are driving my eyes crazy. Aaron Spencer's bid for sheriff. Hold on. Okay, at this time, Aaron Spencer is running for Judges Sturma's judicial. Wait a minute, y'all. Here it says he's running for the judge, not sheriff. I'm confused. Hold on. Hello, welcome in. No, I'm not looking at the AI notes. I just did a straight Google. Okay, here it is. Okay, I re-Googled it. I asked it differently. Okay, Spencer is accused of shooting and killing Michael Fulster in October of 2024. Prosecutors are charged him with second-degree redrum. Despite pending redrum case, Spencer's announced his candidacy for Lonoke County Sheriff. The race has drawn national attention because the candidates are waiting for the redrum trial. How often do you have an actual man who's up from redrum running for sheriff? All right. If you need me, call me. He's publicly framed his run as a response to the system failing his family. So that is where we are. So yes, we all do use AI a little bit, but that was actually just a straight Google search that was giving me multiple things. I'm like, huh? Okay. So let's get back into documents. So just so you have a little context. So Spencer claims that the potential appeal is inadequate because he may be acquitted. So if he's acquitted, okay, in which the acquittal would prevent an appeal. That's a good point there. Let's talk about that. Let me put my mouse on it. I've got the mouse in the wrong second. So what he's basically saying is the only time you get an appeal is if you've been found guilty. And that is true. The only time an appellate issue can be raised. So if he's not found guilty, then that means that the decision for the judge to limit the number of people and who comes into the courtroom from the public is violating his rights before, during trial. And if he should be acquitted, there is no appellate issue, or there is no way that he can turn around and have any recourse whatsoever. That is a good argument, y'all. That is one of the best arguments I have seen, especially when it comes to this document and what I've heard so far. I like that. The argument should be rejected. Taken to logical conclusion, the argument means that any error would be subject to certiorari review because acquittal is always possible. Of course, when you go live with a biggie, your hearing aid decides to go dead. That cannot be law. It is not the law, as this court refusal to grant certiorari in the past cases demonstrates. It is true that prevailing parties cannot appeal. Cited, a party cannot appeal from favorable rulings. Thus, even though he may win the appeal and it's a favorable ruling, his rights as a defendant are still being violated because they are limiting the number of people who can be in the courtroom. But this court has still seen fit to deny extraordinary relief based on the availability of the post-trial appeal. Spencer also claims that post-trial appeal is inadequate because it would not vindicate the right to a public and the media to attend the proceedings. The petition at 7, this argument is too meritless. It is true that Spencer's post-trial appeal would not provide a remedy to the press or the public if they were injured by the client's court's order. But that is why the press, unlike Spencer, can petition the court for certiorari. Well, yes, they can petition the court for it, but it doesn't mean it will be granted, because if the court is limiting and blocking people from attending the trial, do you think that the media, such as, say, if I wanted to go, could petition the court before and during trial, and they're going to deny it? I have no more recourse, because once court's over, it's done, in my humble opinion. Noting that while Spencer has standing to challenge the gag order as a whole, the court did not address. Do you know what, guys? I'm going to do something a little unusual. Give me a second. I'm having a hard time doing the read, so I'm going to move things around and do things a little bit differently. Let me get it up. Okay. I don't pay for this, so excuse it. Oh, come on. Seriously. It's throwing up a billing thing. Now it's saying my thing is not responding. All right, hold on a sec. My program just froze, so I got to go back here and get it. Not your fault. My thing froze, so let me go down and get it. I got to get it back up. Come on, work with me, will you? Y'all, it's been a day. Let me do this. Okay. Open a new window, put it over here. Go here, go here. Okay, open up. There we go. Got it. Okay, let me just get it. Stop with the billing. I refuse to pay. I refuse to pay for some things, y'all. Just saying. I do. I don't think we should have to pay for a program and then turn around and pay to use the program. It just pisses me off. Fit to width. I'm going to share screen now. We got it. Sorry about that. Technical things happen. I hate programs that try to force me to pay for things that I've already semi paid for. Okay, there we go. Yay, that's so much easier to read. Now I got to get back where I was. I think I was over here. Failure particularly stark because let's see if this is the same one. Miss, I need help, Miss June, on this. Is this the same? No. I guess, is that what we were reading, Miss June? No. Okay, guys, this is the first one. We're going to start here. All right. Petitioner Aaron's requests emergency consideration of his petition for a writ accessory and vacate the unconstitutional order issued sua sponte by the circuit court, purportedly in the interest of maintaining courtroom security. Okay, this is the first one. I was reading the second. My apologies. Accidents sometimes can be a good thing. Decorum and an orderly administration of justice. Spencer's jury trial is set to begin in 10 days, January 26th of 2026. The challenge order operates as a de facto courtroom closure by sharply limiting the public and the media attendance as to providing no alternative means for observing the proceedings. Hello, Raven! The violation of Spencer's Sixth Amendment right to the public trial and the First Amendment right to public and the press. The circuit court entered the order without receiving evidence, holding a hearing, identifying and compelling or overriding interests, ensuring that the closure is no broader than necessary, considering reasonable alternatives or making findings required to justify any courtroom closure. The judge wanted to close the courtroom. Basically, what this boils down to. The failure of this particularly stark, but because earlier in the same case, the court expressly instructed the circuit court that any closure must be supported by an evidentiary bias and must comply with the constitutional analysis and required under Walter versus Georgia cited. Rather than adhering to the guidance, the circuit court again imposed a sweeping restriction on public access without constitutional justification. As with the entry of the gag order, the entry in the security order was a plain, manifest, clear, and gross abuse of discretion, and there is no order adequate remedy for the writ. I am. Yes, we're doing a document run through. Y'all share the live. Spencer. Oh, I forgot to do the I like. Give me a sec. Oh, I forgot to give me the I like. I forgot. My apologies. Let me get it. It only takes a second. There. Got it. I like this. Okay, up and running. Y'all don't forget to like. Don't forget to like. Spencer therefore asked the court to grant the writ of certiorari, that's how I'm going to say it, and vacate the security order. Spencer further asked the court to exercise its superintending authority, resign this matter to a different circuit court judge, meaning I want a new judge and I want it now. Emergency consideration is warranted under the Arkansas Supreme Court Rule 6-1 (b) because Spencer's trial is scheduled to begin January 26 or 26, leaving insufficient time for ordinary consideration before irreparable constitutional harm occurs. Okay, so now we're going to get into the background. For those of you who are just joining, hi, I'm Ada K. Don't forget to like, sub, and we have memberships. We do end of the month giveaways. So make sure you comment, I like these beautiful people are. Hello, honey. So basically, you have a guy who is going to trial and the judge is closing the courtroom pretty much. And what's interesting is he's running for sheriff while he's up for redrum at the same time. This is going to be interesting, y'all. So the prosecutional history and background on this case is quite interesting. Spencer is charged by amended felony information with second-degree redrum, along with firearm enhancement for the shooting death of a 67-year-old Michael Fossler. Gosh, dyslexia sucks. The circumstances of the shooting were as follows. July 2024, Fossler was arrested numerous sexual offenses against Spencer's teenage daughter and released on bond. The state later filed 43 felony charges against him. Several months later, on October 8th of 24, Spencer and his wife awoke to a dog barking and realized his daughter was gone. As a result, they called the police, and he left in his truck to search for her. Now, Spencer located Fossler's truck with the daughter inside, and he forced it off the highway. So, truck and daughter, daddy, I'm seeing redneck. That's what I'm seeing. I mean, this is reading like a movie. After the altercation, Spencer called 911 to report that he had shot Fossler, who died on scene. From its inception, the case has drawn intense public scrutiny and debate over the circuit court's decision to release Fossler on a low bond despite facing numerous felony charges and potential life sentence. The propriety of the charge of Spencer for actions taken in defense of himself and his child, and the integrity of local law enforcement given its loss of crucial evidence, including the video of the events that concluded with the shooting. Rather than permitting that scrutiny to occur through open judicial proceedings, the circuit court repeatedly to restrict public access to the information about the case. Y'all, I told you this is movie material. It really is. June, Angela, everybody, I'm so glad I have glasses. This is the first time I've done a document read with real glasses. So much easier. It is. So the story goes, girl was with a man. The man shouldn't have been with the girl. He had multiple charges against him. He shouldn't even been released to the public. Daddy finds girl with the man. He chases him off, knocks him off the road. An altercation happens and a shooting happens. But the evidence with video has disappeared. If I'm understanding this correctly. First, as Spencer's arraignment in November of 24, the circuit court closed the courtroom to the public in violation of Spencer's constitutional rights to a public trial. That is interesting. I want to know why they closed it. And the corresponding right of the public to attend the trial. When defense counsel objected, the circuit court refused to hear the arguments and directed counsel to file a motion and brief, despite that the proceedings would conclude before any relief could be obtained. Ooh, that's not good, y'all. This immediate restriction on public access set the tone for subsequent proceedings. I want to, does anybody here know why the judge stated why the courtroom was closed? What is her defense in doing this? The only time courtrooms really can be closed like this is if it's a minor testifying. You close during the time that the minor is testifying. After the minor is done testifying, you open it back up. What? Oh my gosh, thank you, Raven. I'm fixing it right now. I don't know why. You know how sometimes you put things in and it automatically tries to correct. Let me go in. I'm going to fix that. You're good. Thank you so much for catching it. That's what happens sometimes when you do something quickly. I'm going to fix it right now. Why it did that, I do not know. You are right, my dear. Why am I not able to edit? Give me a minute. A-R-K. I got to be able to spell it. I'll just put A-K. I'll fix it that way. You're right. Thank you so much. Sometimes when you do things, it automatically does things for you. I saved you. All right, we're done. Woohoo! Thank you so much. Y'all are awesome. Thank you. So, after full briefing and oral arguments, the court granted the writ and vacated the gag order, holding that it constituted a plain, manifest, clear, and gross abuse of discretion. In the light of the circuit court closing the courtroom during Spencer's arraignment, the court also cautioned the circuit court against closing further proceedings to the public without evidentiary basis and adherence to the required constitutional analyst set out in Waller versus Georgia, cited. Now Spencer cited. Despite this history, December 18th to 25, the pretrial hearing culminated in what functioned as a partial courtroom closure when the circuit court ejected a member of the defense team from the courtroom without notice, without findings, and adherence to the constitutional framework of governing closures. The attorney seated with the defense staff directly behind counsel's table used a phone in silent mode to research an evidentiary issue at lead counsel's request. Here's the key right there. They have to do it at the lead counsel or the counsel's request while a video exhibit played. without any prior instructions restricting such conduct, and despite no disruption to the proceedings, the circuit court abruptly stopped the video. Do we have a video of this? Ordered the attorney to be removed from the courtroom. Do we know if they have a video for this? Do we know? Oh, that's what the problem is, guys. Okay, guys, I appreciate my mods and all of y'all hopping in on this because this chick is dyslexic as heck. I got to change everything. I apologize, guys. That's my dyslexia, and I just have to live with it. And I just beg your forgiveness. Oh, June or Angela, do you know if there is in fact an actual video anywhere pertaining to this incident? Because this I'd like to see. You have a judge sitting there, did not give instructions stating that you're not allowed to have any of this stuff up and running at any reason for any point in time. And then you turn around and then you do this? That doesn't make sense to me, y'all. Got to change the, I just fixed the thumbnail too. There we go. Save changes. Woo! Got that done. So anyway, Maximo. Sorry, I see Maximo. So she's restricting the courtroom initially from pretty much everybody. And then she kicks out a member of the defense's counsel because at the request of the lead counsel, they were doing research on their cell phone, which is legally they're allowed to do. The circuit court subsequent statements made clear that the removal was prompted by her belief that somebody was reporting on the proceedings via social media rather than by any concern related to the witness intimidation, courtroom disruption, or interests that could justify the limited courtroom closure. Despite well-settled First Amendment protection for reporting on public proceedings, the circuit court suggests that any periodic public reporting on the event inside the courtroom would be prohibited. Yeah, they did not allow the cameras in the courtroom. How am I not surprised? Crucially, on January 13th to 26th, 13 days before trial, the circuit court sua sponte entered a new order invoking, here we go, the interest of maintaining courtroom security, decorum, and orderly administration of justice. The January 13th order sharply limits the public and media access to the Spencer trial. Only 20 members of the media and among the public and media would be permitted to attend voir dire. After the jury is seated, an attendance is limited to 55, inclusive of parties, counsel staff, family members, observers, and media's RP5. The seating, including for media, would be on first-come, first-served basis until the courtroom reaches capacity. The order also prohibits all recording devices, including phones, watches, pads, recorders, and eyeglasses. It's weird now that they're talking about eyeglasses recording things, but that is kind of cool. I'm sorry, I'm a tech. Thank you for sharing, y'all. I am so techie, y'all. I get off on those kind of things. I want some of those. I want recording glasses. I didn't know they made recording glasses. Do they? Man, that would be cool for me to sit in class and record. And nobody knows I'm recording. That'd be cool. The circuit court provided no overflow courtroom, no alternative means for the public to observe the proceeding. No explanation for why such sweeping limitations were necessary, particularly since the courtroom contains many additional seats, both in the galley and inside the rail. As a result, the order operates as a functional courtroom closure. Members of the public and press who wish to observe the trial will be excluded once the number cap is reached, even though the courtroom itself remains open remains normally open. The circuit court made no filings identifying any specific security threat, no overriding or substantial interest likely to be prejudiced, reasonable alternatives, and no findings demonstrating that the restrictions are narrowly tailored. There had been no disruption, violence, or security incidents during prior proceedings that would justify such measures. So basically, this is at the judge's whims. There has been nothing. So the courtroom may hold 100 people. They're limiting it to 55, including the defendant. If he has 2 attorneys, they have 2 support staff. That's 5 right out of the 55. Say they have 5 on the side of the prosecution. That's 10. Then you have media and everybody else. I'm surprised. I'm shocked. Ooh, you can get pins that record as well. Yeah, I did know that. So on January 16th of 26, Spencer also filed a motion in the court to respectfully request that Judge Elmore recuse herself as the presiding judge pursuant to Rule 2.11, parenthesis A, or whatever that is, in the Arkansas Code of Judicial Conduct. Or parentheses, what are they called? Colon. The motion contends that I live in life with FND. Hello. The motion contends that based on cumulative court and of proceedings, the circuit courts impartially might reasonably be questioned. It identifies a pattern of rulings and conduct that creates an appearance that the circuit court has responded defensively to public criticism and appellate intervention rather than correcting course. At the time of filing of this petition, the recusal motion remains pending. If the circuit court denies it or refuses to rule on the motion, Spencer asked the court to reassign his case to preserve both the appearance and the reality of a fair trial. Yes, I agree. And that's my humble opinion. Standards for issuing a writ of certiorari. The writ of certiorari is extraordinary relief. Two requirements must satisfy in order for this court to grant a writ of certiorari. First, a writ of cert is how I'm going to put it in here, lies only when one apparent. It is apparent. It is. Guess I can't highlight. It is apparent on the face of the record that there has been a plain, manifest, clear, and gross abuse of discretion, or 2, the lack of jurisdiction, act in excess of jurisdiction on face of the record or proceedings are erroneous to the face of the record. Second, there can be no other adequate remedy for the writ of cert. This court has held that a writ of certiorari or cert is an appropriate remedy when reviewing discretion to close the courtroom to the public and prior restraint on speech. There is no avenue for relief unless the court intervenes prior to trial. Post-trial appeals would not provide adequate remedy for Spencer's right to a public trial, nor would it vindicate the right of the public and the media to attend the proceedings, particularly in an event of an acquittal. Spencer therefore asks the emergency certiorari relief vacating the January 13 security order. Y'all, I have to say, I'm shocked that judge is getting away with it. How many other times has this judge done this? Does this judge have a record of doing this? Is this her normal mode of operandi, or is this because she's got a bee in her bonnet for them? I don't know. Just wondering. Um, I'm curious. The order was a plain, manifest, clear, and gross abuse of discretion. The sua sponte security order violates First and Sixth Amendments to the U.S. Constitution and Article 2, Cite 6 of 10 in the Arkansas Constitution. No record was developed to support the order. See, one thing people don't realize is a judge gives an order, they can't just say, I order the courtroom closed, bye. No, they have to develop a support for that order. They have to cite law. So if you notice when judges are giving orders that they will sit there and say, I order this courtroom closed under under Supreme Court law, blah, 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 a state, blah, 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 blah. Any minor under the age of 18 may not be videoed, audio recorded. They have a right to privacy, blah, 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 blah. So ordered. That is developed. That's the support for the order. So here they're saying there's no record that was developed to support the order. Wow. I mean, do your job, judge. So, no record developed to support the order. The circuit court made no findings justifying any restriction on public access. They have to give a reason. They have to give a legal based decision for the order. They can't just say, "Oh, I order everyone to wear purple today." It's done. You have to have it cited. It has to be developed. It has to be supported, and it has to be within the confines of the law. The order is on its face a plain, manifest, clear, and gross abuse of discretion and exists of the circuit court's authority. Excess. Both the Sixth Amendment and the U.S. Constitution under Article 2, Cite 10 of the Arkansas Constitution guarantees that in all criminal proceedings, the access shall enjoy the right to a speedy public, here it is, public trial. Not a restricted public trial, not a private trial, not any of it, public. The court has recognized that the right to a public trial is one of the most important safeguards in the prosecution of a person accused of a crime. That is nationally known. In Waller, the U.S. Supreme Court adopted the following test for determining when the rights of the accused to the public trial may give way to other interests, i.e., when the closure of the courtroom is justified in a criminal trial. And we're going to read all these. Number one, the party seeking to close the hearing must advance an override interest that is likely to prejudice. So if keeping the trial public will be prejudicial, the closure must be no broader than necessary to protect that interest. The trial court must consider reasonable alternative to closing the proceedings, and it must make a finding adequate to support that closure. You know, y'all, so, well, there it is. I couldn't find y'all's comments. There they are. Let me get them where they belong. There we go. Now I can see them. Walter versus Georgia, Mitchell versus State. Additionally, the press and the general public have a constitutional right to access the criminal trial under the First Amendment, made applicable to the states through 14th Amendment. So not only does the defendant have a right to the public trial, the public has the right to attend said trial. We have a right to be in there. We have a right to watch, and that is a safeguard for the system. One, to make sure that everything is up and up between the judge and the prosecution. And it's also, we have a right to be participants and view. I'm shocked at this woman. I still kind of mind-boggling. So what happened? The court has recognized that an accused may assert his constitutional right to a public trial by arguing that exclusion of the news media and the public violates that right. He has just as much rights to a public trial as we have just as much right to be there. The Arkansas Constitution is even more broadly protected freedom of speech and of the press. Arkansas, all that is cited. Code cited. The setting of every court shall be public, and every person may freely attend the sittings of every court. Boom. There it is. We've had the claim. Now we got the law. Here is the law cited. She cannot do what she was doing. There has been, now, if this was a minor that was charged, they can close the court in protection of the minor under the rights of a minor. But I don't know how often you can, I don't know. There's not a lot of reasons why you can close a courtroom completely or even partially. The security order effectively closed the courtroom. So January 13th order imposed several limits on the public access to the Spencer trial. Once a jury is seated, let's look at this. Only 55 individuals, inclusive of parties, counsel, staff, family members, observers, and media. That right there limits the public access greatly, because when you take in count parties, the defendant, the counsel staff, the prosecution, the prosecutor attorney, the attorneys, the prosecution attorney staff, and then the victims and our family members, there's not much left for regular public and media access at all. Very minimal left. That is all that she would permit to attend. Seating the first come, first served into the courtroom reaches the capacity of which she set, which was 55, my note added. The courthouse seats more than 55 people, with media included in that same pool. As a result, hold on. Okay, I got an alert. I'm just making sure it wasn't my mods. As a result, if members of the family and the public occupy the available seats first, members of the press may be excluded entirely. Media access is further restricted to a single representative per outlet, and the media must have unspecified credentials. So, yeah, that's interesting. The order does not allow seat reservations. Once an individual visitor leaves the courtroom, their space shall not be held or reserved and may be reassigned to another individual. So if I'm sitting there as a part of media and I have to go to the bathroom and I come back, then the next person in line takes my seat and I'm back at the back of the line again. Although the order creates a limited exception for individual news media that a particular day, it provides no guidance as to what qualifies individual news media or how such an exemption is exemption is obtained. The absence of standards or procedures render the exception illusory, arbitrary. By counting counsel staff, family members towards the 55-person limited, the order ensures that most of the available attendance spots will go to trial participants rather than the observers. The circuit court required the parties to submit a list of counsel team members and family, which together accounted for approximately 40 people. So right here, this was going to be my next question. How many family members were going to attend? What's the actual numbers? What are we actually dealing with? If we're dealing with 55 people limited and we've got 15 people, then you've got 35 people. That's not too bad, but it's still very limiting. So they require the parties to list of counsel team members' families together that 40 individual, approximately. Now, Joe Blow may have a family member that shows up, cousin number twice removed, show up and say, I'm family. He's going to get in. I don't know. This is bothering me. Even allowing for sequestration or scheduling absence, the order leaves only a handful of seats for the public and press to attend at the trial in intense public interest. Let me go to my... Oh, okay. I thought y'all thought you had something to do with me. Oh, you scare me, mods. Okay, the seating restrictions are further exacerbated by the arbitrary limitations on where defense counsel and staff may sit within the courtroom. The circuit court permitted only 3 members of the defense team to sit at counsel's table and prohibited any additional defense staff from sitting inside the rail, behind or close to the counsel table. Well, usually you have the counsel table, you have chairs anywhere from 3 to 4. Sometimes they'll put 2 on the end. That's anywhere from 4 to 6 people. And then you have the rail, and a lot of times they have chairs that are lined up on the rail from that, or the bar forward. So you can potentially have in some courtrooms 10 spaces, including one for the defendant, one, and then the attorneys, and then the paralegals, and all of that. And then if they don't have the chairs sit up against the bar, then they reserve the first row of seats behind the bar for the counsel's staff. Okay. The circuit court permit only 3 members of the defense team behind or close to the counsel table. As a result, the defense staff are required to sit in the gallery outside the rail. So they were not allowed to sit anywhere. Only the attorney and the defendant, any support staff, had to sit behind the bar or the rail, taking seats that otherwise would have been available for public or media. What's on this judge's mind? If the circuit court allowed available space inside the rail to be used by counsel staff, a meaningful number of public seats would have been freed. The restrictions are also difficult to justify given the physical layout of the courtroom. The gallery alone contains at least 75 individual seats, not benches. In addition, the counsel tables are large enough to accommodate more than 3 permitted staff members, which would free up additional seating in the gallery. There's also largely unused area on the opposite side of the courtroom from the jury box, occupied by large conference table that remained empty throughout most of the pretrial proceedings. So they have a wings section. During the pretrial hearings, additional chairs line the walls of the courtroom, providing additional seating. I bet they could get 100 people in there, just spectators alone, not including the prosecution or the defense. The way it sounds. Finally, and we're on page 11 of 16. The order provides no alternative means of public access. It does not allow for overflow room, audio or visual feed, or any other mechanism by which members of the public or the press excluded by the seating cap may observe the proceedings. To the contrary, the order also imposes a sweeping technological restriction, banning all recording devices, including cameras, cell phones, Apple Watches, iPads, recorders, eyeglasses, etc. Boo, I'd be in trouble because I got to have the watch and the phone to be able to manage my hearing aid volume. I have an app on my phone that controls them. I'd be kicked out. As written, this prohibition extends to laptops, tablets, phones used by counsel, even when not used to record. The addition to crippling the defense's ability to manage a case involving extensive digital discovery. The restriction confirms that the circuit court does not intend to provide any audio or visual accommodations to ensure meaningful public access. So we are not going to be able to see this. Guys, mods, question. Are we going to be able to watch this trial? Did they open it up? In the absence of such accommodations, the order closed courtroom doors to all but a small, arbitrary select group, notwithstanding the constitutional presumption of open criminal proceedings. Y'all, this really bothers me. Thank you guys for joining. I greatly appreciate you. January 13 security order was entered without evidentiary bias or adherence to the required constitutional analysis. Contrary to this court's guidance provided to the circuit court via a writ of certiorari or writ of cert, Spencer versus State, the trial court entered the January 13 order without evidentiary bias or adherence to the required constitutional analysis set out in Waller cited. The circuit court entered the new order sua sponte without a motion from either party, without notice of hearing, and without receipt of evidence. No record was developed before the circuit court to demonstrate why the closure of the courtroom was necessary. There's no evidence presented on which the circuit court could have determined that, number one, that there was an overriding substantial interest likely to be prejudiced, or two, how broad any closure might be, or three, what reasonable alternative to the closure might exist. In other words, the judge is, I just got a visual. She's sitting there going, I think I'll close the court. Oh, I'm having wrist pain, y'all. I lifted a box that was too heavy. The circuit court made no findings identifying any specific security threat. So there wasn't a threat made to the security. An overriding or subsequential interest likely to be prejudiced, or what other reasonable alternative it had considered. No findings demonstrating that the restrictions are narrowly tailored or otherwise as necessary to support closure. The circuit court did state, in conclusion, that it finds that this order constitutes a reasonable, narrowly tailored regulation of the courtroom access that fully preserves the defendant's Sixth Amendment right to a public trial while safeguarding the integrity and orderly of the proceedings. That was her excuse. However, without evidentiary foundation or analysis, the bald pronouncement is insufficient to meet the constitutional mandate. Spencer's jury trial is scheduled to begin January 26th. The January 13th order operates as functional courtroom closure and directly conflicts with this court prior ruling and lacks even an attempt to comply with the constitutional framework in Waller. For these reasons, it is apparent that from the face of this order that it is plain, manifest, clear, and gross abuse of discretion. What are y'all thinking about this, guys? I want your opinions. Do you believe that this judge needs to be recused? Someone's at my front door. Give me a minute. I got to see if it's somebody I want to deal with or not. Because this chick don't want to do that. I think it was a mailman. Exercise of superintending duty is appropriate to reassign this case. The court has exercised. That's what I want to see. I want to see if I think my new glasses are in because these have a crack. The court has exercised superintendent authority to grant expedited relief, expedited relief, and reassign the case when a circuit court persists in conducting that undermines the public confidence of the judiciary. Cited. Exercise of that authority is appropriate here. As detailed in Spencer's motion for judicial recusal filed in circuit court, and we will look at that on January 16th. Can I have a mod? Can one of y'all grab that and throw it into Ada Working, please? Yes, I know, June. I saw that. The hockey team, we're talking about hockey. So now the judge, they've asked the judge to remove herself. And of course, do you think she removed herself? Absolutely not. Sorry. I'm having to manage some alerts. All right. Circuit court action follows. The court remand did not reflect the correction or restraint. Despite the court's express mandated emphasizing that the constitutional presumption of openness, the circuit court continued to restrict the access. So the access was continued to be restricted to the public record, including excluding a defense attorney from the public pretrial hearing based on suspicion of social media reporting, and ultimately entered an order that at least partially closes the courtroom during trial. I find it interesting that it's my understanding that when somebody is on the legal team, that they are permitted to have their devices with them because they look up law, they help the attorney, they do citing, they look up documents. I mean, they've got to be able to have their devices with them. And for them to be thrown out of the courtroom under the premise of, oh, you're posting social media, that's a slap in their face. That is so disrespectful and blazing. If in fact that's the case, the judge would have to have proof. Those actions did not occur in isolation. They were accompanied by an extraordinary security force at the December pretrial hearing, one far exceeding anything reasonably justified by the circumstances of this case. Although Spencer is a non-custodial defendant with no history of escape, attempt, or disruption of prior proceedings, at least 4 and sometimes as many as 6 Arkansas State police officers were stationed inside the courtroom at all times. Additional officers occupied hallways, stairways, elevators, and building entrances. Police vehicles ranged from the courthouse and established an outer perimeter while drones patrolled overhead. What? All because of this trial. Do you know how much money they're spending on this, y'all? Wow. Drones overhead for him? Parking in surrounding lots were prohibited. All attendees were searched, electronics banned, and even defense counsel's briefcases were inspected. From outside, the courthouse appeared closed to the public. Counsel has reason to believe that even greater show of force will accompany the trial. Is this the Karen Reed trial? Is that what they're thinking this is going to be? I don't know. Viewed cumulatively, these measures discourage public attendance. Yeah, greatly. If I walked up to my courthouse and I couldn't park in the courthouse parking, there was that many police officers there. Well, we don't, only when going into trial, I think, do we go through metal detectors. We can enter the courthouse at any time without being searched. Wow, that would deter me. Even though I have nothing to hide, that would be a lot to get in. The cumulative measures discourage public attendance, insulting both the state conduct and the circuit court's own decisions from contemporaneous scrutiny. Contemporaneous scrutiny. They convey the message that Spencer is too dangerous for a public trial, that the public cannot trust to witness it. And those who speak out about what occurred may face sanctions. Wow. Thank you, Addie. It's me. That message fosters an appearance of bias and erodes confidence in the judicial process. Whoa. These concerns are heightened here. Spencer is a declared candidate for public office. So is that what they're saying? The reason why all of this is there is not only is he brought up on charges, but he's also a candidate for public office of sheriff at the same time. With a primary election approaching March 3rd of 2026, and his political opponent is both a witness in this case and a public official with whom the circuit court has worked professionally for more than a decade. In that context, continued efforts to limit public access amplifies the appearance of bias and entrenches the perception that the circuit court is responding to scrutiny by constricting it rather than adhering to the court mandate. So, are they saying that, in other words, he is he is he saying is he saying that, well, by not having them in there, okay, he's running for office, by not having the courts open is going to affect the election as well. So this is not just about court, it's about the election to me as well. Hold on a second, guys. I got to take a quick break. I'll be right. The court has where a court responds to, wait, did I mention the entrenched perception of this word responding scrutiny, considering rather than by adhering to, okay, where a court responds, okay, to an appellate correction, not by conforming its conduct, but by entrenching it, the court investigation is necessary to preserve both the appearance of reality and impartiality. For those reasons, Spencer respectfully asks the court to grant emergency consideration, issue the writ of cert vacating the January 13 order, and exercise its superintending authority to reassign the matter to a different circuit court judge. Okay, so that was done. I got to go find the next one. LiveCom. The trial has been delayed. The hearing is scheduled March 16th of 2026. Okay. So now I need to go in. Let me get into the file because I had them all pulled up, but since we had to go in and reboot everything, it kind of sucked. Oh, Maximo's great. I'm sorry. Let me go to court documents, the Supreme Court. What is this? So on Monday, 6/2/25, 11 a.m. from Barbara Elmore to blank is typed out. As you both must be aware, Supreme Court vacated gag order. In accordance, I expect a mandate after the time for rehearings reached its limit. Once a mandate is received, access to information will be ordered. Okay, that's not what I'm looking for. Okay, let's share this. Dagnabbit, I don't want that. Boo. This is not what I want. Hold on. There we go. I'm going to get rid of that. All right. This is the mandate petition for writ of cert granted. Writ issue circuit court gag order vacated May 29th of 2025. Here's the order. Excuse me. I'm sorry. These allergies have been a nightmare. State of Arkansas appellee. The petition for writ of certiorari to the Lonoke County Circuit Court was submitted to Arkansas Supreme Court on the record of the Lonoke County Circuit Court and brief of the respective parties. After due consideration, it is the decision of the court that the petition for the writ of cert is granted. Writ issued. Circuit Court gag order vacated for the reasons set out in the attached opinion. And we have a long opinion, very long opinion, but it is an opinion. We've already gone through the background, so I'm going to skip the background. It's just regurgitating the background. But I want to see what this says. It is ordered of this court that no party to this action, nor any attorney or agency connected with this case, directly or indirectly, nor any judicial employee or officer of the court, nor any public official now holding office, including but not limited to law enforcement officials or any agent, deputy, or employee of such persons, nor any person subpoenaed to testify at the trial in this case, neither shall the defendant nor his family shall do any of the following. Okay, let's go here. December 10th, 24, holding a hearing, without holding the hearing. Okay. Release or authorize relief of public dissemination of any purported judicial statement of the defendant relating to this case. You cannot do this. You cannot release or authorize the release of any documents or exhibits or any evidence admissibly for which may have to be determined by the court. You make statements of the public dissemination as to the extent or possible existence of any document, exhibits, or any other evidence. They cannot express outside of the court an opinion or make any comment for the public dissemination as to the right value or the effect of any evidence as tending to establish the guilt or innocence of the defendant. This is the suppression order. Make any statement outside the court for public dissemination as to the weight, value, effect of any testimony that's been given. In other words, they can't talk about it. They can't issue any statement for the public dissemination to identify any prospective witnesses or probable testimony or the effect thereof. They can't tell you who's going to be on the stand or give any hint at that, who they might call. Thank you. Make any court statement for public dissemination as of the weight, value, source, or effect of the purported evidence alleged to have been accumulated as a result. So they can't talk about the evidence. They can't make any statement for public dissemination of the content, nature, substance, or the effect of any testimony which may be given in the proceedings released in the manner for attorney of record or any agent thereof. So they can't talk about what the testimony may be. But this order does not include factual statements of the defense, name, age, residence, occupation, or family status. So they're not allowed to talk about the case and the witnesses and what their evidence may be. But they can sit there and slam the name, his age, where he lives. They can give out his address. They can tell people where he works. And they can talk about the family status. Either you could talk about the case or you can't. Oh, they can tell you the circumstances of the arrest, namely the time and place of the arrest, the identity of the arresting investigating officer, agency, and the length of the investigation. So they can give you that. They can tell you about the nature and substance and the text of the charges. including brief description of the offense charged. So they can tell you what he was charged with. Quotes from any reference without comment to the public records of the court in this case, or to the public records of communication here. They can talk about the scheduling, the results of any stage or judicial proceedings. Okay. They can request for assistance in obtaining evidence. They can talk about that. They can talk about or discuss why by any witness or prospective witness of any matter in connection with the case with any of the attorney represented in the defendant's case. So it's interesting. That to me, all parties and the defendants are under gag order. You can't talk about it. The order also goes on to require that a copy of the order be attached to any subpoena served to any witness in the matter, or redaction of any information violating the gag order from any paperwork related to the case might be disseminated to the public. So anything they may send to your to the public will have to be redacted. So we're going to keep we've already talked about this. We're going to go down the Spencer's argued that the gag order violates, and we'll read this, the First Amendment because it's on an unjustified prior restriction on certain content based on categories of speech. He further argues that the circuit court exceeded its jurisdiction when it placed overbroad restrictions on the speech of non-parties without due process. It's one thing for them to put a gag order on the lawyers and the defendant and the prosecution, but they can't put a gag order on non-parties without due process. The state responds that the circuit court order was within constitutional limits, protects the integrity of the case, and ensures fair trial for both Spencer and the state. For this reason that follows, we hold that the circuit court's action in entering the challenged gag order was on the face plain, manifest, clear, and gross abuse of discretion and in excess of its authority. Further, there is no order adequate remedy for the exempt without a writ of cert. Here we're talking about the general rights. Constitutional rights and personal rights may not be raised by a third party. However, the issue raised in this petition for extraordinary writ requires us to consider restrictions not directed towards Spencer personally, and we decline to uphold any part of the order in light of the order's clerk lack of an evidentiary bias basis as a whole. Here, the circuit court order is extremely broad as it's a person's restrained from speaking. It restrains the parties, the attorneys, any public official now holding office, along with their staff, witnesses, court staff, and the defendant's family. The order also extremely restricts, restrictive as to what information is being shielded from the public view. It restricts filings and perhaps courtroom proceedings from public view. Okay, we've already gone through that. Freedom of speech, we've talked about that a little bit, but let's go ahead and read this section. The First Amendment in the United States Constitution provides in part, Congress shall make no law abridging, I can't say that, freedom of speech. The First Amendment is made applicable to the states by the 14th Amendment. Similarly, Article 2, Section 6 of the Arkansas Constitution provides the following. The free communication of thoughts and opinions is one of the most valuable rights of man, and all persons, may freely, write and publish their statements on all subjects. Spencer relies on both the United States Constitution and the Arkansas Constitution in arguing that the gag order case violates his and others' free speech rights. However, free speech rights are not absolute and in rare cases must yield to the Sixth Amendment guarantee of a fair trial by impartial jury. You remember in the Karen Reed, there was a gag order, meaning they couldn't sit there and talk to the press or anybody about the case publicly. But that doesn't mean I, as a second cousin to the defendant, couldn't say anything. The gag order is defined as a judge's order directing parties, attorneys, witnesses, or journalists to refrain from publicly discussing the facts in the case. Thus, the gag order, by definition, a prior restraint on speech. Prior restraint on speech and publications are the most serious and the least tolerable infringement on the First Amendment rights. As such, a prior restraint on speech bears a heavy presumption against the constitutional validity. In fact, the Supreme Court has recognized that criticism of the state lie at the very center of the First Amendment. This could include speech critical of judges, prosecutors, and public defenders and law enforcement. It would be difficult. And by the way, don't you love how you can see where they copied and pasted things? The text is real dark, then it's light, and then it's dark. It's driving me crazy. It would be difficult to single out any aspect of government of higher concern and importance to the people than the matter in which criminal trials are conducted. The Supreme Court of the United States has only directly addressed the constitutionality of the gag order as they apply to the press, not as to the attorney, parties, witnesses, and public. That means you can't talk to the press about it. Nor has the Supreme Court articulated the legal standard for when, if at all, such prior restraints would be permissible. In Nebraska press, the court considered gag orders on the press and strongly disapproved of such prior restraints except in extraordinary circumstances. The court noted that pretrial publicity, even if persuasive and concentrated, cannot be regarded as lending automatically and in every kind of criminal case to an unfair trial. The court states that it was required to determine whether the gravity of the evil, discounted by its improbability, justifies such invasion of free speech as it is necessary to avoid the danger. Courts examined the evidence before the trial judge when the order was entered and determined the nature and extent of the pretrial news coverage, whether other measures would be likely to mitigate the effect of the unrestrained pretrial publicity, how effective a restraining order would operate to prevent the threatening danger, and whether the precise terms of the restraining order were too broad or too vague. The court considered the circumstances under the attorneys may be published after speaking. The court upheld the prohibition on speech and that persists a substantial likelihood of materially prejudicing an adjudicatory proceeding. So in other words, the Supreme Court held the speech of the lawyers representing the clients in pending cases may be regulated under less demanding standards than establishing a regulation of the press. So they can tell the press, you can't do this, you can't do that, you can't say this, you can't say that. They can't put a gag order on them. But the family and other people who are not lawyers or press, that's what I'm kind of confused about. Here, the gag order was intended to address the need to protect the integrity of the jury pool, to ensure that all parties get a fair trial, in light of pretrial publicity. When considered pretrial publicity, the trial court has the different job of balancing constitutional interests while upholding its affirmative duty to protect the integrity of the criminal justice process. Supreme Court made it very clear in Shepard versus Maxwell when it guaranteed habeas relief to petitioner who had been deprived of a fair trial in his state red room conviction because of the trial judge failure to protect him from massive, persuasive, and prejudicial publicity and from the carnival atmosphere at the trial itself. The Shepard court noted that the trial court might well have prescribed an extrajudicial statement by lawyer, party, witness, or court official which divulge prejudicial matters. Wow. Now, we recognize that the Shepherd was an extreme case in which there was no doubt that the deluge of publicity reached at least some of the jury. So I get it to a point, but this judge went off. I'm trying to get to. Well, all right, Rob, determining which standards to apply, we must initially recognize whose speech is to be restricted. That's where I wanted to get. If we can identify three categories of the persons potentially subject to the gag order: the attorney of record, the non-attorney trial participants, such as criminal defendant, witness, and court staff, and three, the public at large, those who are not participating in the trial. Because the gag order entered here includes members of all three categories, we reviewed each to establish the appropriate. First, we address the attorneys. The attorneys can be. I'm going to skip that. Next, we talk about the free speech rights of non-attorney trial participants. These persons are not subject to the same rules and restrictions as the attorneys. And this particular judge has put everybody under the same ball of wax, and you can't do that. But as participants in the trial, their speech has the potential to have a greater impact on the speech of the non-trial participants. Neither prosecutors, counsel for the defense, or the accused witness or court staff, nor enforcement officers coming under judicial jurisdiction of the court should be permitted to frustrate its function. Thus, we conclude that free speech protection for non-attorney personnel participants are greater than those of the attorney of record, but less than those of the public at large. So they're kind of like, you got the extremely tight, closed-in free speech up here, then you've got the media. Yeah, we got to do some regulations, and then what do we do with the public? Therefore, we hold that the speech of the non-attorney participants may be restrained only to the extent that it poses a serious and imminent threat of material prejudice of the ongoing general. Okay, so they can do them. But now this is what I want to look at. This right here, the prior restraint of the public. That's my question. Whose speech is afforded the most protection in the context of the gag order? Restraining the speech of the public raises obvious issues regarding the lack of due process. We cannot fathom why the circuit court would believe it could prohibit the speech of any public official now holding office. In fact, it is difficult to foresee any circumstance in which prior restraint on speech of the member of the public, which would include public officials, could be constitutional. Having established the legal standards to be applied, we turn to the additional findings that circuit court must make in every case to justify the entry of a gag order restricting speech in any individual. First, circuit court must determine whether alternative measures would protect the parties. Here, Spencer suggests that the inclusion of voir dire and prospective jurors using an expanded jury pool, giving cautionary instructions, changing venues, or postponing the trial or alternatives should be considered before restraining speech. So in other words, they're saying we can change venues, we can get jurors from different surrounding counties. There are other things we can do before you should consider restraining the public speech. But the circuit court heard no evidence and made no filings in this regard. In addition, the circuit court must find that the gag order would likely to accomplish the goal of preventing prejudice to the proceedings. I'll be honest, the crap's already out of the horse at this point. Again, there's no such findings in the case. Finally, the gag order must narrowly tailor to prohibit only what is necessary to protect the integrity of the ongoing judicial proceedings. Due process, it's overbroad, it's overbreached. There's 34 pages. We've still got a ton to go. Here we go. Sealing the case. Finally, we addressed a court circuit decision to seal the case. Spencer contends that the community has a right to know what the government does in a public court proceedings. He cites Arkansas Code annotated section, blah, 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 cited with the setting of every court shall be public. Every person may freely attend. We've already gone through this. The conclusion that the circuit court gag order is far too broad. We've already seen all this. Okay, so we have documents from individual judges who are seated on the Supreme Court. Aaron, this is Rhonda Wood, Associate Justice. Spencer argues, we know what he argues. Okay, text and history. When we interpret constitutional provisions, we will begin with the text but determine its plain and ordinary meaning by examining it in light of its history. So what that means is all the cited and all the stuff that they brought up, we're going to look at it, but we're going to look at how has it been used in the past? What other cases have this been used in the past? What were the decisions? What were the verdicts? So they're going to look at the history of the cited reference, and they're going to examine it based on the light of its history. It is well accepted that we look beyond the words, but also their public meaning at the time in history. We may also compare previous versions of our Constitution to interpret the meaning. Let me look at this footnote real quick. No, these are the sites that she's talking about. Free speech and free press provisions in the Arkansas Constitution protects the Arkansas Constitution freedom of speech, and the press date back as far to the first Arkansas Constitution, which was adopted in 1836. Article 2 provided as follows. Boy, this is really old. This is over 100-year-old, but this is what it states. That printing press printing press. The old wheel printing. Okay. Printing press shall be free to every person, and no law shall ever be made to restrain the rights thereof. The free communication of thoughts and opinions is one of the invaluable rights of a man, woman. Every citizen may freely speak, write, and print on any subject being reasonable for the abuse of that liberty. Section 8. The prosecution for the publication of these papers investigating the official conduct of officers or men in public capacity, or women or persons, or where as matter the publish is proper for public information. The truth thereof may be given in evidence and in all indictments or for libels, the jury shall have the right to determine the law and the facts. So they're saying that's up to the jury. This language is common to other early states' constitutional date back to at least the 1790s. Oh, wow. That's old. Contrast with the First Amendment of the Constitution of the United States. Congress shall make no law abridging the freedom of speech or of the press. Highlights the state choose to use language different from that in federal constitution, and that they were understood at the time to protect the freedom of speech and of the press inherent in natural law development in the law. Okay. So she's saying that Arkansas adopted subsequent constitution back in 1868. There, the language was moved, and the decision of prosecution for libel was incorporated into the section of the freedom of speech press. The language was overhauled and became our current section, Article 2 and 6. And it states, liberty of press and speech. Liberty of press shall forever remain inviolate. The free communication of thoughts and opinions is one of the invaluable rights of man, and all persons may freely write and publish their statement on all subjects, being reasonable for the abuse of such rights. In all criminal prosecutions for libel, the truth may be given in evidence to the jury, and if it shall appear in the jury that the matter charged as libelous to true and was published with good motives and for justifiable ends, the party charged shall be acquitted. Emphasis added. In its current form, Arkansas provisions is quite different from its federal counterpart, which allows us to interpret it differently. Next, we evaluate the text in historical context. Early on, our courts recognized that free speech right must be interpreted by more than a simple textualist manner, and that we should look to history surrounding it. Sorry. The main purpose for such constitutional provisions is to prevent all such previous restraints upon publications as had been practiced by other governments, and they do not prevent the subsequent punishment of such as may be deemed contrary to public welfare. Let's go down here. The court considered whether the freedom of the press precluded the contempt order and found it did not. Here's where I want to go. Any citizen has a right to publish the proceeding and decisions of the court, and if he deemed it necessary for public good, to comment upon them freely. What we do here every day, discuss the correctiveness, the fitness, or unfairness of the judges for their stations, and the fidelity in which they perform the important public trust reposed to them. But he has no right to attempt by defamatory publications to degrade the tribunal, destroy the public confidence in it, to depose community, to disregard and set not its order, judgment, and decrees. Such publications are abuse of liberty, press, and tend to sap the very foundation of good order and well-being in society. So in other words, you can print about it, you can talk about it, as long as you're not defaming. I'm going to skim down just a little bit. We've got so much to go through. I want to get to their answer. Okay, here it is. Arkansas consideration. I agree with their creation, but I would adopt them for under Arkansas consideration. I concur with the judgment. Supreme Court. This is all of them, y'all. An effort to shield these proceedings from public view also didn't begin. I may want to read this one. It doesn't seem too long. Public officials aren't immune from public criticism, judges and prosecutors included. Because the circuit court gag order violated that principle, I joined the majority opinion granting the writ and vacating the order. But that sweeping order is only one part of the troubling pattern of attempt to shield this case from the public view, beginning with the non-public arraignment and ending with the handwritten note sealed the entire case from public view. We cannot allow the pattern to continue unchecked. So I invoke this court's superintending authority and resign this matter to a new circuit court judge. They got a new judge. Beginning with the gag order itself, it's on its face. The order targeted a broad swath of people, barring them from expressing an opinion or making any comment, without whether the evidence tends to establish the guilt or innocence of the defendant. Worse, the order itself was sealed, raising serious concerns about the selective enforcement. Not only did she give an order without grounds, without law, without merit, without citation, without any basis, she sealed it. Really? Raising serious concerns about the selective enforcement, and it doesn't explain why such an extreme remedy was warranted. There's no explanation. There's nothing. It was given and that was it, which is not how it goes. Instead of just declaring it would help ensure all parties get a fair trial, nor did the circuit court explain why it extended the gag order beyond what even the state thought it was appropriate. So she didn't just extend it to the appropriate party, she extended it beyond, and even the state said, what the hell are you doing? Broadening it to cover the defendant's family, and even more significantly, sealed the entire case. Record strat, my brain just went. On the contrary, the circuit court entered that order just 6 minutes after the clerk docket the defendant a 19-page opposition to the state motion. Barely enough time to make a pot of coffee. I like this judge. I like the way he talks. This I get. The approach cannot be squared with the First Amendment and underscores the gag order wasn't a least resort, but an unconstitutional impulse. Wow. Snap. You're now saying that this judge not only didn't do her job, but it was a violation of the First Amendment right and underscores the gag order as the way they should be, and it was an unconstitutional impulse. Wow, I like this. Context suggests why. The same circuit court that issued the gag order here also granted Michael Fulsler release on bail. So here's the case. Here's where the victim's family have a lot of people have a problem. The same judge that's doing all this is who put the gag order in and then sealed the gag order and sealed all the court documents is also the same judge that allowed Michael Fulsler free on bail. Well, not free. He released him on bail. When most people who did what he did would not have been out on bail. Are y'all still here, guys? Y'all got real quiet. It's that decision, which the defendant's lawyers called a decision to release a predator. Huh? So you got the Supreme Judge telling the lower court judge, dude, you released a predator who repeatedly violated the defendant child while on a low bond. It wasn't like it was a $500,000 bond. It wasn't like it was a $200,000 bond. I don't know what the bond was, but it was quite low. Does any of my mods know what the bond was? I don't know what the bond was. That set off a chain of events that led to the fatal confrontation that the subject of this case. So in other words, you were partly responsible for what happened here, Judge. And it is that criticism the state claimed that the circuit court effectively concluded, justifying the gagging of the defendant, his lawyers, and others. So they're saying, oh, well, the judge did the gag order in self-preservation, in my humble opinion. Wow. I need a visual of this judge. I want to get a visual of who this judge is. I want the background of this judge. I'll look into that in a minute if I can find it. Indeed, if openness enhances the appearance of fairness so essential to the public confidence in the system, this then secretly, this has opposite effect. It erodes the trust. And I agree 100%. Boy, are they going to bring charges on this judge? Can this judge be brought on charges? I want to know. I want to know what the judge's record is. The effort to shield these proceedings from public view also didn't begin with the gag order. It started with the circuit court's decision to arraign the defendant away from public view. The defendant wasn't even arraigned in public. And sorry, let me get this. Even setting aside potential constitutional concerns raised by a non-public arraignment, the decision highlights the order to review here isn't an isolated problem. What? Okay, that's cited. We've already read that. Confident of the person by secrecy. Rather, it suggests that star chamber like atmosphere. We cannot allow this to continue. I have my gavel in the other room. Ultimately, judges and prosecutors enjoy no greater immunity from criticism than other persons or institutions. Public vengeance serves us well, for the knowledge that every criminal trial is subject to contemporaneous review. I did good on that. A forum of public opinion is effective restraint on possible abuse of the judicial power. Cited under our system of government, the primary check against prosecutional abuse is political one. Instead, justice should not only be done, but should manifestly and undoubtedly be seen to be done. So I join the majority decision granting the writ and vacating the gag order, but I would also go a step further. I repeat attempts to the repeated attempts to veil this proceeding is secrecy can only breed ignorance and distrust of the courts and suspicion concerning the competency and impartiality of the entire judicial system. Remedy that danger warrants strong medicine, and I apply it. Where is everybody? We all need to be reading this one. Oh my gosh, that was good. And it's signed, sealed, delivered. It's yours. Let me see. Okay, I've already done that one. So we just did. Give me a minute. I got to switch. No, I don't. Yay. But I do got to make it fit the page. Fit height. Read mode. No. Come on. Ah. Fit to width. There we go. Get all this stuff out. Okay. Formal order. The state of Arkansas Supreme Court. Be it remembered that a session of the Supreme Court began and held in the county of Little Rock on February 28th of 25. Amongst others were the following proceeding to wit. Petitioner's motion to stay the proceedings in the circuit court. Come on. Where's my mouse? There we go. Take petition for the writ of certiorari as a case. Set a briefing schedule. Requests for an oral argument are granted. Petitioner's motion to leave to file tendered reply is denied. Petitioner and respondents simultaneous opening briefs are due by Friday, March 14th, noon. Petitioner and respondent simultaneous response briefs are due by Friday, March 21st. So there is the order. Open up. Here is the petition. I think this is the one that we were reading before. Yeah, we've already done. Yeah, we've already done that. Okay. I got to separate this stuff out. Hold on a minute, because every time I do something, it Will you be obedient? Nothing is obeying me on my computer today. I put something somewhere and it goes wherever it wants to go. Hold on. Once is enough. Thank you. I'm having technical problems. Give me a second. Everything is wigging out over here. It's going wherever it wants to go and it's not obeying me. Okay. I lost my StreamYard. Okay, what is this, June? It's a lot of, this is hard for me to read this fast. You found the oral arguments for this case once in the... Oh my gosh, I can't. 2566. I don't see anything that says 2566. June. Everything says 2324. I don't. There it is. Oh, video. June, you freaking rock. Everybody give June a big round of applause. Hopefully you can hear this. Give me a minute. I got to get it set up. But Miss June, you freaking rock. I don't know how you do it, Miss June. I don't know how you and Angela do it. I try to find something that's like, hey. But they found it. Oral arguments. Woohoo. Okay, now I'm going to have to try to get this organized in a manner and get it all set up in a way that we can play, expand. I'll turn up the volume. Oh, look at all these women. Oh, y'all are amazing. Thank you, June. It's hard reading all this, guys.
We have cases to hand down this morning. Justice Womack, would you start?
You're freaking amazing, June.
CB 24-283, Kenneth W. Tilley, individually and as trustee of the Kenneth Tilley Family Trust versus Malvern National Bank and Stephen Moore from Garland County Circuit Court, affirmed in part, reversed and remanded in part. Justice Baker and Hudson and Highland concur in part and dissent in part. Justice Wood concurs.
Now, we may hear other people's too, so we'll just wait and see.
Justice Webb.
CB 24-127, Jeremy Kennedy versus John Feltz, Director, Arkansas Parole Board.
Justice Highland.
Case number CR 24-563, Jason Meredith versus State of Arkansas. It's an appeal out of the Circuit Court of Saline County.
Okay, that's not
in preparation over the last few weeks.
Arguably, you could be, because arguably you're discussing it for purposes of public dissemination. I mean, presumably you intended to come here and ask questions about it, and you intend to publish an opinion that pertains to it. So I suppose arguably you could be. That seems outrageous.
So even if you assume that that's all true, I mean, I guess I'm confused. What's your standing to raise those arguments as to non-parties? I mean, I understand that Mr. Spencer can raise the argument as to him.
Okay, we're going to go back. We're going to go back.
But is to anybody else covered by the...
We're just going to go back and watch. We're just going to let it roll.
Submitted to the court today. They're all criminal cases. The first one's our oral argument this morning. That is CR 2566, Aaron Spencer versus the State of Arkansas from Lonoke County Circuit Court. The cases submitted on the briefs in the record are CR 23-401, Morgan and Weatherford versus the state from Logan Circuit, CR 24-143, Dennis Hale versus the state from Sevier Circuit, CR 24-157, Elizabeth Haney versus the state from Ouachita Circuit, CR 24-240, Warren Goodrum versus the state from Pulaski Circuit, and CR 24-353, Devin Romick versus the state from Crawford Circuit. In addition to these 6 appeals, there are 20 various other motions and petitions submitted today. More information about these appeals is available at the court's website or by contacting the clerk's office.
Thank you. Are there any motions from attorneys or parties present?
No, Your Honor.
No, Your Honor.
At this time, then, we will take up the oral argument scheduled for this morning. CR 2566, Aaron Spencer versus State of Arkansas from Lonoke County Circuit Court. And I acknowledge the petitioner's attorney to come forward. Ms. Casanelli. And you've reserved 10 minutes for rebuttal, is that correct?
Yes, Your Honor.
You may proceed.
Thank you. May it please the court, counsel, I'm Erin Casanelli, and I, along with Michael Kaiser, represent Aaron Spencer, who's the petitioner before this court and the defendant in the court below. We are here today on a gag order imposed at the inception of a criminal case in the circuit court. Gag orders should be a last resort, not a first impulse in any case. And I would submit to you that's fairly settled law. The law requires a careful analysis and a balancing of important constitutional interests when imposing a gag order. The law requires further a very narrowly tailored order that is specific to the case, the interests in the case, and the interests of the public in receiving speech and the parties in providing speech. This court, federal courts, the criminal justice system does not favor justice in the dark. And that is what is happening in Lonoke County. In this particular case, this gag order is very important.
Guys, look at the body language. Watch her body language. Oh, you can tell she ain't happy. She's all, let me tell you about it. Just watch the body language too.
This is an unusual case. I don't know how much factual information has been conveyed to this court, but it's unusual in several respects. Aaron Spencer is a father and a husband. His daughter was assaulted, sexually assaulted, severely, by a man named Michael Fossler. Michael Fossler was arrested and charged with over 40 criminal offenses relating to his behavior against Mr. Spencer's child. He was released by the Circuit Court of Lonoke County with very little restriction.
So counsel, if I can interrupt you right there, just a factual clarification. Was it the same judge who issued the gag order was the judge in that case?
Yes, sir, and thank you for that question. You caught exactly where I was going. It was the same circuit court and the same prosecutor who participated in Michael Fossler's criminal proceeding. And that's important in additional respects. There is no public record of his appearance that I can find before the circuit court. There's no record of what bond the state sought, why the court imposed such a low bond, why there were no restrictions or supervision as to his conduct. And of course, that led to him taking Aaron Spencer's daughter in the middle of the night to continue to rape her.
Counsel, I have a question. We live stream our court proceedings, and this is a public hearing. So, and it's live streamed. It's also saved on our website. Is that violating the current gag order?
That is an excellent question, and also on my list of things to discuss before this court. This gag order is so overbroad that I don't know that I can answer that question precisely. My belief is that this court has asked for this argument, and I cannot fulfill my duty to this court without explaining the facts and the law that apply to it. But the way the gag order is written, none of you could speak about the case from the bench here. The governor herself couldn't speak about the case if she wanted to. No public official could speak about the case.
Counsel, in preparation for the argument, all the court has 2 law clerks on staff, 2 attorneys. Were we in violation of the order when we were discussing it with our law clerks in preparation over the last few weeks?
Arguably, you could be, because arguably you're discussing it for purposes of public dissemination. I mean, presumably you intended to come here and ask questions about it, and you intend to publish an opinion that pertains to it. So I suppose arguably you could be. That seems outrageous.
So even if you assume that that's all true, I mean, I guess I'm confused. What's your standing to raise those arguments as to non-parties? I mean, I understand that Mr. Spencer can raise the argument as to him, and he can raise it presumptively as to counsel. But as to anybody else covered by this order, what standing do you have?
Yes, sir. There are several things that sort of fall into that category, but as a general matter, the overbreadth doctrine allows courts to consider First Amendment restraints that affect third parties. So I think that's discussed in the Murphy-Brown case, which cites a couple of Supreme Court cases for that point.
But for overbreadth to apply as a general matter, you have to first allege that this can be constitutionally applied to you. The reason why we conduct the overbreadth analysis is because it's constitutional as applied to you, but it's unconstitutional theoretically as applied to others. Here, your argument is it's not constitutional as applied to you. So I'm a little bit confused how we get to overbreadth.
Well, either way, I think it's unconstitutional as applied to my client, in part because it's overbroad and it encompasses both his right to speak and his right to receive speech. The First Amendment covers the communication itself on both ends, which is why all the cases
Are there cases that treat overbreadth that way? I mean, I'm not familiar with any Supreme
No,
Court
that's
cases.
a bit of a different doctrine. So think of all of the cases most of the cases that are out there involve the press, right? The press is coming forward and saying, we oppose this gag order that you have imposed that prevents all the parties from speaking. And the press is the recipient of that speech. And most often the defendant doesn't want the speech, but the press is still allowed to bring that motion. At times the parties bring the motion, but they are addressing whether they can speak and whether speech can be provided, for instance, in public records.
Then I guess my question is, if we found the gag order is unconstitutional to you, your client, is that sufficient, or are you seeking more relief and that's why you've argued overbreadth? Because normally if we said it was unconstitutional as applied to you, the analysis would stop. There's a stack of First Amendment cases that say that. The analysis stops. Would you be satisfied with that relief, or are you seeking to invalidate the entire gag order? And again, what's the standing for that?
I don't think that the court has to go that far, because I think that it's unconstitutional as to Aaron Spencer, and that would cover all of the concerns, because there's really not a part of this order that is sufficiently clear, that indicates a substantial compelling interest, that's narrowly tailored. So I think that if the court decides that the order itself does not comply with constitutional mandates, then that is sufficient to get to the end, which is that it needs to be submitted back to the circuit court for a proper analysis.
So a slightly different variation of this question then. What I took some of your arguments to be framed as, yes, they were sometimes framed in terms of overbreadth. I thought maybe you were making a facial challenge as to the gag order itself and just arguing it's unconstitutional in all of its applications. Am I wrong about that? Or?
That's a tough question for me to answer. I believe that it is facially unconstitutional, but I don't think the court has to reach that point. I think for purposes of our argument, pointing out the circuit court's disregard for the rights of the people that it encompassed in the order, And for the
But that
overbroad,
sounds like a facial challenge, right? That when you start talking about other people, if it's an overbreath challenge and we decide that it's unconstitutional as to you, the analysis stops. So you've either got to say it's a facial challenge or it's not really an overbreath challenge at that point. So which is it if you're talking about other people?
well, I think what the point that I'm trying to make is I think that that is important evidence of the order's overbreadth and the problem with the circuit court's lack of analysis. I think that
Counsel, perhaps what I thought I heard you say earlier was that it wasn't just that you're arguing that prohibiting the defendant's speech. It was his receiving speech as well. And is that why it, in a sense, you're arguing it's unconstitutional, the restrictions on others is because it prevents them from him receiving their speech?
Your Honor, thank you, Justice Wood. My point there was just that the First Amendment protections are both as to recipient and speaker. In this instance, our position is that Aaron Spencer, the attorneys, the people that represent him, his family, any interested party should both be able to speak and have access to the information necessary to speak. So, for instance, closing all court records. And by the way, there were no court records made public. So even the affidavit of arrest or the charging document aren't public. But he has a right to access those records and share them with other people. That is speech.
That seems to be slicing it, I mean, putting too much emphasis on one point. I mean, courts seal records all the time for various reasons. Now, maybe you don't think there's sufficient justification here. There, as far as I can tell, there really are no fact findings here. So maybe it's not warranted here, but there's not some abstract right. I mean, I don't think you can identify a case, can you, where the courts have recognized an abstract right to access information that says courts can't seal their records.
I'm sorry, Your Honor. I believe that the right to a public trial includes the right of public access to court records.
Does it include the right to release evidence that you obtain in discovery then, in your view?
No, I think discovery is treated differently. Discovery is regulated under court rules. I'm, as an attorney, prevented from disseminating discovery material. There's no need for a gag order in that respect. The court rules cover that. So I think the case law also suggests that discovery, the United States Supreme Court has addressed that discovery is a separate and protected class. I'm dealing only with the public record aspect, and I agree with you that absolutely the court can seal records after the appropriate analysis has been undertaken that shows a need to do so. In this instance, we have sealed every public record. In fact, I noticed that since we filed the final brief in this case, the circuit court clerk has added some notations to the electronic docket online. But while we were doing briefing, you couldn't even see the title of documents that were filed. There's no record of my client's entry of a not guilty plea. The public was prevented.
Read correctly at some point that the arraignment was actually sealed?
The arraignment, the court would not allow community members in the arraignment. I raised an objection. It was not well taken. And so they were not allowed in the courtroom.
So no members of the public, no members of the press allowed at the arraignment?
I can't swear to that because my back was to them, but I watched the bailiff and heard him tell numerous members of the public that the court had ordered that only 2 members of the defendant's family and I believe 2 members of the victim's family would be permitted in. Whether or not he ultimately let somebody slide in, I cannot attest to that, but he turned away a line of people, and it wasn't 100 people, it was about 8 or 10, and he turned them all away.
But counsel, we haven't even, are you raising a right to public trial? Because we haven't, extended that beyond we haven't extended that to arraignment and further.
No, Your Honor, I'm not, but it is an important consideration here because Aaron Spencer may not have taken so much issue with this gag order if it didn't seem like this entire proceeding and the entire proceeding of Michael Fossler were being conducted in secret. And the public, members of Lonoke County, have a great interest in knowing how this happened and knowing why its public officials are making the decisions that they are.
Ms. Casanelli, you said something a minute ago that made me think that the remedy you're seeking here is for this court to remand or send us back to Lonoke County circuit court to have a hearing. Is that what you're asking for?
I'm asking this court to vacate the gag order and to provide the court and all courts in Arkansas with some kind of analysis, some kind of careful balancing, some direction, and order the circuit court and all circuit courts to conduct such analysis before they impose a gag order to ensure that it is appropriately narrowly tailored, only as is necessary to prevent substantial prejudice. That's what I'm asking for. And in this instance, the circuit court undertook no analysis, took no evidence. So there is nothing on which a tailored gag order could be created and imposed.
So the standard you just articulated, which case does that come from? I mean, I know that the cases say various things at various times. It's a little bit unclear what the U.S. Supreme Court has told us the standard is here. Where are you getting your standard from? What is the closest match? And is it the same standard applied to everybody that this gag order applies to, or is it just the standard that applies to you and your client?
So I would submit to you that the standard doesn't matter. Under any of the standards that have been laid forth by the Supreme Court, this gag order fails. I could talk all day long about whether Gentile sets a standard or Nebraska Press should be used, but I don't think my evaluation is that there is not a rigid test. I think the Supreme Court has said repeatedly, like the clear and present danger is not a formula. It is an indication of the careful balancing that should be done to ensure that a gag order is addressed only to a substantial and compelling public
But
interest.
the balancing language, where does that come from? I'm not familiar with a case that says balance.
Nearly every U.S. Supreme Court case talks about the weighing or the balancing.
But does it actually apply a balancing test as one would traditionally think of it? Or does it just say we balance in formulating the standard, we balance the interest? Or is it a pure balancing test?
It is not a pure balancing test. The court has been clear that it's unique to every case, but that it has to have the hallmarks of applying the heavy presumption of unconstitutionality as to a prior restraint, such as a gag order.
And in response to Justice Hudson's question, you were asked, what are you seeking here? Are you just seeking sending it back for hearing? And you said you'd like guidance, but what I just heard from you is an amorphous test that doesn't really provide that. I mean,
unfortunately, the United States Supreme Court hasn't addressed this situation because most often it's a defendant's assertion of a right to a fair trial that was not honored because of change of venue, or it's a press case. So I think we're looking to this court to help us in the state, to help us combine those cases and come up with what is the proper direction. But I do not mean to insinuate or indicate at all that there is a rigid balancing, because I think that the constitutional rights at issue don't allow for that. It's going
do
to
I
be
take
different.
from your answer then that you think the standard varies depending on whether the state has asked for it versus you've asked for it?
No, I do not think the standard varies. I think that the circumstances of the case are necessarily going to make, for instance, the state's compelling interest in a fair trial is going to have a different weight under the circumstances of each different case, as will the need to narrowly tailor the order. It necessarily has to be specific to the case, but we could use some real guidance as to what courts have to do to evaluate those issues.
Your time has expired. You can continue into your rebuttal, or
Thank you.
thank you. And the attorney for respondent.
Thank you. Madam Chief Justice, and may it please the court, I'm Assistant Attorney General Joseph Carl Lukey here today on behalf of the respondent, the state of Arkansas. The circuit court's gag order in this case was an appropriate exercise of its discretion that helps achieve its primary constitutional duty to ensure a fair trial occurs in this case and that justice is done. Reviewing this order and Spencer's claims under the intermediate scrutiny standard set out in Gentile versus State Bar of Nevada.
Counselor, what would be the harm in sending this back to circuit court for an evidentiary hearing?
I think the harm is that there is sufficient evidence in the record to support the order here. It is undisputed, they didn't dispute it below, they haven't disputed it here, that there was sufficient media attention, expansive media attention, that supports the idea that there is a substantial likelihood of material prejudice based on statements from trial participants. And so, and then the other thing you have is the statement that was attached to the state's order, which represented an effort on the part of the defendants and his attorneys to try this case in the press. And when you have a clear attempt to try the case in the court of public opinion rather than the courtroom, then it is appropriate to prevent.
Wasn't there just one statement here? I mean, you only attached, I think, one statement from defense counsel. I mean, that seems like a little bit of a jump to say there's been one statement that the defendant says was in response to something that the prosecutor had said cryptically. Like, that seems like a bit of a jump, doesn't it?
There is only the one statement in the record. That's correct, Justice Bronny. But I think when you read that statement, you can see the intent behind it. And the fact that it was in response, or may have been in response to statements made from the state, those statements aren't in the record. The fact that the state may or may not have made statements only further supports the need for the gag order. The fact that both sides are talking means that a gag order is appropriate. And when you read the substance of the statement, it contains a style of argument that wouldn't be allowed in court. It has evidence as to the character of the accused and the character of the victim that may or may not be admissible. And so this court, the circuit court, needed to ensure that the case is decided based on the evidence that comes from the witness stand, and that's what the gag order does.
But you jump from one point to the other. I guess where I'm confused is I'm not aware of a case that says you have a right to the state or anybody else, a right to a trial without any publicity, which almost seems like what happened here. The circuit court decided there should not be any publicity. Instead, your right is to an impartial jury,
That's
right?
correct.
And why wouldn't things like voir dire be sufficient for dealing with that? I didn't see any findings to that effect here.
One, I think because voir dire was raised in the defendant's briefing below, it's implicit that it was rejected by the circuit court. I think you can find an implicit finding there. And I think what the Shepard versus Maxwell case says, and what Gentile itself says, is that when we're looking at ensuring a fair trial, the court has to act prospectively to prevent prejudice before it happens.
Counselor, let me ask you something. I think you just said that it was included in the defendant's objection below. Are you talking about the 19-page objection that they filed to the request for the gag order?
Yeah, I think they mentioned.
So how quick, and you said that because it was included, it's fair to assume that the circuit court considered that and rejected that. Is that a fair assessment of your argument on that point?
I think you can assume that.
Okay, so let me ask you, how quickly do you read?
As quickly as I can, Your
So
Honor.
if you had to guess, how many pages per minute do you think you read?
If I'm reading carefully, a page a minute, probably.
So if the defendant in this case filed a 19-page objection, and 6 minutes after that was uploaded to the system, after the clerk accepted it and uploaded it to the system, the circuit court, 6 minutes, the circuit court filed the answer with multiple handwritten interlineations in the order, excuse me. Do you think that we can fairly assume that in those 6 minutes, from the time the 19-page objection went live until the time the circuit court filed her order, that she read, considered, and gave due weight to the defendant's objection in this case?
First of all, I would reject the premise of the question. I don't think there's any evidence. They have alleged 6 minutes in their briefing, but all we have in the limited record before this court is the file stamps. And the file stamps of the order and the file stamp of the response indicate 2 separate days. That's all this court has to consider. And I don't know that we can know for sure whether or not the court had access to the response before it was pushed through by the clerk. I can't speak to that. I know the response was before the court and it had the opportunity to consider it. So I think we can find an implicit
Counsel,
finding here.
let me ask you another question. When you're talking about discretion, and I think that's what Justice Womack's getting to, you said the court exercised discretion. This order is substantially the same as an order that we vacated in 2020 in the Arkansas Democrat Gazette case when they brought a writ of cert to this court. So I guess how much discretion really was there? And it wasn't a carefully crafted order because it's obviously looks like a standard order that's being passed around either by prosecutors or by judges at the circuit court level. And so that's my question is, why would we treat it any different than the case we vacated in 2020?
I think you're dealing with who's making the petitioner here. The petition is the defendant, not the press, and we treat press cases differently than those of the defendant. And I think when you're looking at the order here and whether it's narrowly tailored, I would compare
But
the
we
categories.
vacated it completely. We didn't just vacate it as to the press. We completely vacated it. And it had the same limits as to the defendant, the family, the friends, judicial officers. It was exact, I mean, same language.
I'm not aware of that case, so I can't speak to that, and I apologize for that. But what I would ask this court to do is compare the restrictions here with the restrictions that were present in the rule in Gentile, and they are very similar. The rule in Gentile is found in the appendix to one of the opinions, and that was found to be narrowly tailored for First Amendment purposes. And so I think that this order
For purposes of the defendant's counsel, perhaps, but one, it wasn't a prior restraint, right, in Gentile, so that's different. And that was a case about defendant's counsel. Here, I think you concede, correct, that this order goes beyond defendant's counsel and applies to the defendant. Why doesn't that make a difference? Where do you get from Gentile that standard applies to others?
I think two things in response to that, Your Honor. In terms of why it would apply to the defendant and other parties, Gentile, while it did specifically address lawyers, some of its language said, because lawyers have special access to information through discovery, client communications, extrajudicial statements, their statements are likely to be received as authoritative. All the parties here that are restrained are in the same boat. A statement from the defendant is likely to be received as authoritative because he knows what happened. And so the same justification that applies to lawyers would apply to him. I would also say that while Gentile dealt with a subsequent punishment, the bar rule at issue there was a prior restraint on the attorney's speech. It was a rule that existed that restrained the entire attorney's speech. He was then subsequently punished. But I think it can be viewed as a prior restraint.
So that one, you could make the argument in Gentile that was people directly connected. There is language to that effect, but here we have an order that applies to any public official now holding office.
Yeah, and my first response to that, Your Honor, would be that those claims aren't in front of this court. The defendant doesn't have standing to raise them. And then secondly, while I say that public officials may be broad and probably could be reformed, the idea that some public officials, like the sheriff who investigated the case, court clerk, other people who might have knowledge and were specifically directed, I think would fall into the same category as attorneys, defendants.
So answer the question that was raised earlier by one of the other justices. We're public officials. We all have clerks and administrative assistants. This morning I sat in my office and discussed this case with the 3 people that work for me. And we talked about the evidence and we talked about the issues involved. Did I violate Judge Elmore's gag order?
No.
Why not? Because it says any public official now holding office.
Because the restraints in the gag order are for public dissemination. Your discussions in your chamber are private. And in fact, they're exempted from FOIA, that you have a right to in crafting opinions.
Facebook post by the Lieutenant Governor. Covered, not covered by this gag order.
Arguably covered by this gag order, and I think the state would concede that that's probably inappropriate. She doesn't have any special knowledge.
You say inappropriate, do you mean unconstitutional?
I don't know that it's necessarily unconstitutional, but I don't think it was, I don't think that claim is before this court.
So your boss is the Attorney General. Every legislative session, the Attorney General has a package of bills. Let's say he wants to go to the legislature and ask for a bill that addresses this very situation. He wants to add an affirmative defense to the statute in this type of scenario and has to give the reason why he wants to do that. So he lays out the facts of this case.
I mean, we're party litigants to this case. I'm responding.
Okay, so let's say it's the governor's package.
I think the
Did the governor violate Judge Elmore's gag order in doing that?
I think the term public officials is probably, if the public officials claim were before this court, it's the general proposition of public officials is probably too broad and should be reformed.
So what about family?
I
Whose
think-
family? Is that spouse and kids? Is that the fourth cousin you met once at a family reunion 30 years ago that's talking about it at the coffee shop?
And I think that is part of the problem with the general term family, and it's the limits of the English language that perhaps that was not something the state requested. That's something the circuit court did on its own. I do think it is appropriate to restrain certain family members for the reasons I said. Spencer can't filter his speech through his wife or his mother or people that they would see as authoritative. But I think it would be appropriate.
Then are you reading in the provision that talks about release, to Justice Womack's question, release any purported extrajudicial statement? Are you reading that as a limitation into the family language? Or I guess I'm a little confused as to the position.
I'm sorry, could you repeat that?
So the first here is basically you can't launder the statement provision. Any purported extrajudicial statement of the defendant. Are you reading that limitation into the family provision, or?
I think the order says that the family is a restrained party and that is a restrained speech. So I think that would apply. I think that's a fair reading of the
So
order.
counsel, if defendant planned to call his daughter to testify, he couldn't publicly announce that, correct?
No, under the terms of the gag order, the identity of witnesses are protected. I
But-
think-
Then why is that necessary if you can publicly say the arresting, investigating officers and agencies are public and they're going to be necessarily witnesses? So why can the defendant not release his witnesses, but obviously the state can publicly name some of their witnesses?
And I think that, first, I think that the defendant's daughter could be a witness either for the state or for the defendant, same as the investigating officers could be witnesses for either. And I just think that the terms of the order says that you're allowed to identify the arresting officers, but you're not allowed to release witness lists, and that's to try to ensure a fair trial by preventing witness.
A fair trial for who?
A fair trial for the public and a fair trial for Mr. Spencer. It's a fair trial for all parties involved and for the people of this state.
Can I ask about the overbreath thing? Because I'm not sure that I got a clear answer from opposing counsel about whether they're raising an overbreath challenge, but it's certainly in their brief. What is your view of how we would conduct that inquiry? Because normally you have a statute, it's very clear, there's one standard that would apply across the board. It might be unconstitutional, or it might be constitutional as to a particular person before the court, unconstitutional as to others. Here, assume for a second with me that the court has set different standards for different people, or certainly different articulations of the standard for different people. So what do I do on the front end to determine whether or not there's substantial overbreath? Do I have to go through every group in the order and apply a different standard and say, well, it's okay here, it's not okay there? So I add them all up and somehow it's substantially overbroad? Or how do I do that in the state's view?
I'm not sure I can answer that question. And I think your question demonstrates why an overbreath challenge isn't appropriate here and wasn't raised here. They're raising separate challenges as it is to his speech, as it is to the other speech. They're raising a bunch of different as-applied challenges. They don't have standing to assert it on behalf of those other parties, and that's the problem. And I think that there is a possibility that different standards could apply to different parties, which wouldn't lend itself to an overbreath challenge.
And then
the general public, sorry.
On that standard, then, I guess, what is your view of what Gentile says and what Nebraska Press says, and what is the difference between those two standards?
Nebraska Press is they deal
with different people, I'll give you that. But other than that, what is the difference in the articulation of the standard?
I think not only do they deal with different people, they deal with different First Amendment rights. One is dealing with free press and one is dealing with free speech. And those are different delineated rights in the Constitution. I think that open press, they talk about there being open discussion in this case in the public. We view that with much greater scrutiny in the law. Whereas the trial participants, what Gentile has said, what Shepard has said, and what Nebraska Press has said are viewed under a much lesser standard because it gives the court room to balance fair trial versus those First Amendment
So
rights.
why does the different standard matter here? Because as I understood your articulation of the interest here, I think your view would be that you survive strict scrutiny. So like, what is the relevant difference in the standards here? Because you started by saying this is intermediate scrutiny. So you obviously care about the standard. I guess I'm trying to figure out, why does that matter here then?
Well, it matters here because not only are we trying to ensure a just result in this case, but we're setting the standard going forward and for future cases. That's what this court does. And I think it matters specifically where intermediate scrutiny versus strict scrutiny matters in this case is when it comes to what narrowly tailored means, and specifically the consideration of least restrictive means. Under intermediate scrutiny, this court does not have to, or the circuit court did not have to choose the least restrictive means of choosing its goal.
That's generally true, but doesn't some of the language in Gentile indicate that maybe this is like intermediate scrutiny with a bite almost?
No, I didn't read it that way at all, Your Honor. I think the language specifically said that the court doesn't have to rely on things like voir dire and a change of venue because those will come after the damage is done. We don't know and cannot know that, as Nebraska Press, the known and unknowable, whether or not they will be sufficient to do the job. And given the primary constitutional duty of the court is to ensure a fair trial, it's important that they act
So
prospectively.
your primary interest then is in avoiding tainting the jury pool? That's the state's interest here, or is there another interest?
Yeah, well, I think it's in ensuring a fair trial, which involves tainting the jury pool and protecting the witnesses from harassment. I think there's twofold. I think if you read the restriction in the order about the identity of witnesses, that would go towards protecting witnesses.
So what about then the restrictions on making statements about a witness's testimony after the witness has already testified? What purpose does that possibly serve with respect to either the jury pool or intimidating witnesses?
I think it depends upon whether those statements are made in a pretrial hearing or in a trial. I could see and concede that when the jury has already been seated, that there wouldn't be reasons to restrict statements anymore to the press as long as the jury is sufficiently sequestered or sufficiently instructed not to
Counsel,
read press
and
accounts.
it feels as if the discussions that you're having with my colleague are having well-reasoned discussions about where this perhaps could have been limited more, tailored more, and that would have been the benefit of having a hearing in front of the trial court, where the trial court could have had these discussions about what really the harms were out there, what you were trying to prevent, and that would have happened rather than sort of whether it happened in a day or 6 minutes, a quick form response.
I think the circuit court had all the information it needed in front of it to craft the order that it did, and I think that order is narrowly tailored. It specifically targets public dissemination of the evidence in this case, and just that, and that's to prevent
And the
ensure.
fatal flaw with that is that we vacated a virtually identical order in 2020.
And I think that Gentile would say that
Well, it
this,
doesn't really matter, does it? That's US. We're saying an Arkansas case.
I think when we're applying the First Amendment, what the United States Supreme Court says matters.
Well, I would disagree when they've raised an Arkansas constitutional right here.
And I don't know that
We can give more protections, correct?
we can give more protections. They did not develop an Arkansas constitutional argument. I don't think, while they did cite it, they did not develop it. They
It's hard to
purely
do
relied.
without a hearing, isn't it?
I
develop
think they
that
could have
argument.
developed it in their briefing. They had a full briefing schedule. This court requested additional briefing. I
But
would
would it
just-
matter if that prior order from this court was a syllabus entry instead of a reasoned opinion? Does it make a
I think
difference?
it does make a difference because I think the important thing today, and what I would say in closing, is we want to adopt a good standard moving forward. It's important to ensure that justice isn't done in this case, but this court's opinions matter going forward. And so I would ask this court to adopt the Gentile standard because it gives the court room.
Counselor, I know you said you were closing, but I have a question for you. On the last page of the order, right above the judge's signature, it says the entire case is now sealed. What does that mean?
It means that the public docket and the docket entries are no longer public. That's what I took it to mean.
That's what you took it to mean? Do we know what that means? Does that mean that we're not going to let the public into the various hearings and portions of the trial that happen going forward? What, do we have any extrapolation somewhere else in another document from the judge to kind of expound on, you know, what she meant when she said the case is now sealed, the entire case is now sealed?
No, the only thing I'm aware of is the order before this court. And I think when we talk about sealing, I took that to mean sealing in the record. The defendant has a right to a fair public trial, and I have no reason to believe that that's not going to happen. I'm out of time. I would ask this court to deny the petition for writ of certiorari. Thank you.
Okay. Number one, what are your thoughts so far? Please put them in the comments. Number two, this woman is in front of the state Supreme Court, not liking her semi-casual dress, in my humble opinion. But anyway, that's not important. Thank you so much for sharing and liking. And please tell me what your thoughts are so far. I'm holding mine.
Counselor, as it applies to the other party, the non-parties and the non-participants, so essentially the family members and let me make sure I get the precise language, any public official now holding office, as it applies to them, by having a gag order on them, is there any prejudicial impact on your client's rights to a fair trial or your client's constitutional rights otherwise? And if so, what is that prejudicial impact?
I would say there is a prejudicial impact. Each case that I believe in state court and in federal court that's evaluated gag orders in a similar way has addressed the scope of coverage as to third parties or groups of covered third parties. I should have made that more clear earlier, whether or not it was specific as to a very precise prejudicial effect on the defendant. However, to answer your question, I do believe there's a prejudicial effect. I think my client has a right for the public to be aware of what's going on in his case, for the public to be able to access records so that the public can make its own assessments of how it feels about its public officials and about how its criminal justice system is being operated. He is a member of the public. While he's also a criminal defendant, he is a citizen of Lono County, and so is his family, and so are his children. And so I think it does impact him and prejudice him, both as a citizen and as a criminal defendant. And I think every case that's analyzed this has, without real discussion, evaluated the scope as it applies to other people, as well as the scope of its application to different types of speech and other matters. So I think that that's a proper consideration. And it also, as I said before, contributes to the court's finding that the order is not narrowly tailored.
The cases that you're referring to that do that, they generally do that either because it's a press case or because it's an overbreath. So take Murphy Brown, for instance. Judge Wilkinson's opinion basically just says, we're applying overbreath analysis, never does sort of a preliminary determination of how that would work. So the same question that I asked the state, how do I conduct that analysis? Do I have to do some different test application? Assume with me for a second that I disagreed that strict scrutiny automatically applies to all of it. If I have to do that, how do I do that analysis, sort of the preliminary front-end analysis? Or wouldn't it have been easier to frame it as a facial challenge?
I think you can tell that I think that's a tough question. I think that there are different standards that apply, and unfortunately here none was applied. So any standard would be better than no standard, but I think the court does have to consider what burden must be met to prevent non-parties from speaking. I don't disagree with the state that trial participants can be restrained in ways that are more substantial than third parties, people who are not within the proceeding. I can't legitimately dispute that. But the cases, Nebraska Press, Shepard, they don't articulate for lower courts how to do that. No Supreme Court case does. which is why we're having this discussion and why there's not a defined answer to it. But I think the circuit court has a duty to take care to address those categories of persons in specific ways, because those rights are different and they are to be evaluated differently. I want to be sure to state to the court, there is no case that applies intermediate scrutiny to gag orders to this circumstance. There just isn't. There's no case that dispenses with the least restrictive means analysis. Gentile does not do that. In that case, it was a subsequent punishment at issue, not a prior restraint. That cannot be reasonably disputed. The Supreme Court has told us that those things are viewed differently and prior restraints are
It says that, but when have they ever actually indicated how the standard is different? I mean, I recognize you're entirely right. The court has said prior restraints are treated differently. Tradition in this country, we treat them differently. But when it comes to actually analyzing them, can you point to the delta in the way that the court has treated them differently?
Yes, I think the court historically has consistently held that prior restraints are what they call freezing speech as opposed to chilling it. Because when you speak in the face of a rule that tells you of an ethical rule, you are aware of the danger in doing so. It's very different.
I agree with you in those general terms, the court has said that, but where has it applied a different standard?
I don't know that that's specifically come before any court. I mean, I cannot think of a case where that has been specifically addressed. In my mind, that is something that is stated repeatedly. The evaluations of rules like the ethical rule in Gentile have been evaluated slightly differently. I would say this as it pertains to Gentile in this analysis, that because it was a regulatory rule, the court was looking at the systemic issues. So the court was looking, they didn't dispense with the least restrictive means. They didn't have a case to apply that analysis to. So in that instance, they're looking at a rule. Is this necessary in a profession that we as a state license? Can we impose this ethical responsibility? And how does that rule affect sort of the systemic costs that may be associated with it? In a case in a trial court, I mean, we don't hear circuit courts say, well, you know what, we're not going to do extensive voir dire because it's too expensive. You know, we're not going to change venue even though maybe a defendant's entitled to it because it would just be too much of a cost on the system. I mean, Gentile is obviously dealing with the overall systemic assessment, but within the First Amendment analysis.
Well, counsel, I think what the state was saying is that they thought that perhaps some of what you said in a statement, you could not have said in court. Would you agree with that?
I'm sorry, I could not have said.
You could not have said in the court. You could have not made some of those statements.
Well, I have sort of agree and disagree.
Okay. Well, and so I guess following that is that once you did that, was there a legitimate concern by the court that maybe you were going to keep going further, and then that justified the court issuing some sort of gag order, if maybe not this far, against at least counsel?
I think the court, and I think the Trump court talks about this in that opinion, that context is important, and that has been completely ignored by the state in its briefing before this court. That statement was made before arraignment, before there was any proceeding. It is a criticism of a public official. It doesn't include any information that is prejudicial or would be inadmissible. The character of my client will be at issue because he is of outstanding character, and there's nothing that's going to impact that. Michael Fossler's rapes of Mr. Spencer's child are public record. It is a part of this case. And that statement is geared very specifically towards the prosecutor's decision to charge him after months of us cooperating and after knowing the circumstances that led us to that point. The very person who was responsible for Michael Fossler's case. So
was there a potential of suggesting jury nullification?
I do not believe so, because I think in a justification context that the jury has to assess what a reasonable person in Aaron Spencer's shoes would have done. There really wasn't a golden rule type argument, definitely not in the written statement. I want the court to know that the one comment that I made on camera at arraignment, which is also when a prosecutor made a comment on camera, what's recounted in the motion is a mash. I made brief statements, but they were related to the circuit courts having iced the community out of the proceeding. So if you don't take them in context, you may think that I'm talking about the jury as the community, but I'm actually, in full context, was talking about the community's involvement and support of him in that proceeding and being told to go home. So I think if the court had taken evidence, then we could have fleshed all of this out. My practice is not to try my cases in the press, and I would have probably agreed to some restrictions as necessary, depending on what they were. But the court didn't evaluate any of those things. And of course, the court didn't find out what I was speaking in response to. But I submit to you that there's really nothing in that written statement that should be even prejudicial. Even under the current gag order, his occupation, his family history, all of that is apparently okay to speak about. Public records are okay to speak about, and those are based on public records. So, I mean, just because the prosecutor doesn't like it, that is not a reason, that's not a justification for a gag order.
So if we construed this order narrowly, I realize it might be somewhat difficult to do, and just treated it as a poorly written order and construed it as most of the provisions have to do. I mean, there's the one about extrajudicial statements of the defendant, but otherwise, for the most part, what we're talking about are public dissemination or public comments about evidence, prospective witnesses, testimony, etc. If that was construed narrowly to be limited to statements about that are aimed at basically tainting the jury pool, releasing evidence, commenting on evidence, that kind of thing, does that give you the relief you actually are seeking, or is that not enough? And would that pass? I mean, the other question is whether that passes relevant test.
It's difficult to answer that in the abstract. This order says things like possible existence of evidence. Like, I don't know what the possible existence of evidence is. You know, if we could define those contours better, then perhaps so. But, you know, some things that are potential evidence or possible evidence should be fair game for the public to learn about too. So I think we should be narrowing this to prejudicial evidence, not anything that possibly could ever be evidence. And not all of this order addresses even public dissemination. And I'm sort of unclear even what that term encompasses. You know, social media is a big thing. There was lots of comments on social media. If family members have private social media accounts, is that public dissemination?
Does it matter that the state conceded that a Facebook post would be covered by this order?
The state in its briefing suggested so. I'm not sure I agree with that. I think that may not be public dissemination. I've been asked these questions and I can't give the answer any more clearly than anybody else from reading that order. I want to point out to the court that we do dispute the extent of the media coverage, the undisputed nature. Everything is in dispute here. Yes, there was media coverage. I don't think it was near as extensive as I've seen in many other cases, but we don't know because the court didn't take any evidence, so there's no basis for that statement. There's no basis for the statement that our written statement was the cause for the gag order. Nobody even alleged that in the motion. Nobody found that in the order. So I don't think that that's a fact that the court can rely on. I also want to suggest to the court as to the standard, and by the way, there's no evidence of risk to witnesses. No one has even raised that. That was commented on a moment ago. I don't know where that came from. There's been no allegation of that, no indication of that. But as to the standard, I do not deny that Gentile may provide some general baseline test for trial participants, but it cannot be the only expression of a test because of the limitations that we've discussed previously as to the regulatory nature and the lack of prior restraint. I think the court has to consider the heavy weight of the First Amendment rights that are at issue and honor those. And here, Aaron Spencer's not asking for a gag order. It's his Sixth Amendment right to a fair trial. And that is usually raised by the defendant in cases where the defendant attacks a gag order. We are not doing that here. So there's not a Sixth Amendment right as competing with a First Amendment right, as is discussed. I think Nebraska Press talks about how the founders didn't tell us which one should win the day. But that's not the issue here. The public has a right to a fair trial, sure, but they also have a right to hear my client's speech and to know what's going on in their judicial system. Thank you.
Okay, we'll dismiss the court.
What did I get unmuted? I was getting ready to unmute myself. What do you think about that? Yep, that's interesting. So that is what an oral argument in the Supreme Court looks like. So now what we're going to do, we have a couple other things we're going to view. I'm going to try and do it in order. Okay, I don't want to do that. I got missing Arkansas Supreme Court. Let's see if there's a video. Hold on. Okay, I'm going to read this to you. I don't know why it's highlighted in pink. I don't know why, but it is. I'm going to share all this on screen. I got to separate. Everything's kind of wacky over here. Let me separate everything and get it back to where I can function with it. There we go. Okay, so let me get this back up. Share screen. Share screen. Share screen. Here we go. The Arkansas Supreme Court on Friday afternoon. Arkansas Supreme Court removes judge presiding over Aaron Spencer's Red Room case. And I have all the documents and everything, so we're going to go through it. The Arkansas Supreme Court on Friday afternoon removed a judge presiding over Aaron Spencer's Red Room case in Lonoke County, granting a petition Spencer's attorney filed last week that said the judge's actions threatened Spencer's rights. Spencer's trial, which Judge Barbara Elmore of the 23rd Judicial Court Circuit on Friday morning delayed to February 12th, began because of, I got to do it. I got to read it from over here. It's too small. Because of approaching winter storm is now on hold until Supreme Court appoints a new special judge to replace Elmore. The order states, now Elmore's rejected a request from Spencer's attorney to recuse herself on Thursday. A response from an assistant attorney general had attacked the Supreme Court not to grant Spencer's petition, stated that he could always appeal the outcome of the case, and rejecting Spencer's claim that his right had been violated. The order does not elaborate on the court's reasoning, only noting that the Chief Justice Karen Baker and Associated Justice County Hudson and Rhonda Wood would not have granted Spencer's request to remove Elmore, overturned her January 13 order limiting attendance at the trial and barring recording devices from the courtroom. The order came in the day after 14 members of the Arkansas House of Representatives sent a letter to Emily Abbott, Executive Director of the Arkansas Judicial Discipline and Disability Commission, expressing concerns that Spencer had not been getting a fair trial under Elmore. Representative Jeremiah Moore and Clarendon, Joey Carr of Blytheville, Marcus Richmond of Harvey, Britt McKenzie of Roger, I'm not going to read all those, signed the letter. The restriction of Elmore Place on trial attendance and extraordinary security measures risk undermining the presumption of innocence Spencer is entitled to, the letter states. It refers to the Supreme Court decision to invoke Elmore's gag order last year. We respect judicial independence, but we take our obligation seriously to ensure the constitutional rights are protected. Spencer petitioned the Supreme Court filed in late January 16th with a request for emergency consideration, argued that Elmore's restrictions on attendance of only 55 people, including attorneys and family members, will be permitted in the courtroom amount to closing the trial to the public and infringing on Spencer's rights to a public trial. Elmore justified her order by noting that small size of the courtroom, saying the limited on attendance was necessary to preserve security and decorum. Earlier this week, Elmore wrote that the court has received threats over the case, but she hasn't detailed those. So she's saying there's threats, but she's not shared those threats with anybody. On Friday, posts on Facebook, Spencer's wife, Heather, reposted a scan of the Supreme Court order. Aha! I just so thankful right now, she wrote. Aaron Spencer, 37, is charged with second-degree murder in the October 8th of 2024 unaliving of Michael Falser. Spencer encountered Falser earlier that morning while searching for his daughter, who was then 14, and found her in Falser's truck. Spencer rammed the truck off the road before shooting. Spencer said lunged at him with something in his hands. Falser was free on bond at the time of his death, awaiting trial on numerous accounts of actual crimes against children. And the defense team said that Spencer's daughter was a victim of those offenses, which led to Falser's July 24. What I don't understand, explain to me this. If this guy perpetrated inappropriate acts against Spencer's daughter, why is Spencer's daughter in the car with him? Why or how was that permitted? Wouldn't there have been a restraining order at that point if he's brought on criminal justice? And why was the girl willingly going with him? This is what I want to know. Spencer defense team argued that the lead shooting was an act of self-defense and that Foster posed a grave threat to Spencer and his daughter. On Friday afternoon, Erin Casanelli, Spencer's lead attorney, said that she was grateful and relieved to get the Supreme Court order. I quote, "I hate it had to come to that, but I'm glad they intervened because this just not the situation that needs to have a dark cloud of suspicion and secrecy around it." Spencer's petition also reference to the Supreme Court on May 25 order lifted the gag order of Elmore placed on the case in December 24. The court ruled that at the time that the gag order was overly broad and infringed on Spencer's constitutional rights, and it cautioned Elmore to use discretion in limiting coverage to the case and moving forward. So they said, boo, you can't do that. And if you're going to do that, now that you've done that and we've overturned it, be careful what you do moving forward, which she did not take to heed. Aaron and Heather Spencer were hearing Friday morning, in which Elmore delayed the trial. The hearing was scheduled for Elmore to reconsider allowing testimony from one of the defense team expert witness who expertise Elmore in December rejected as whose expertise, irrelevant to the trial. However, Elmore granted a request for the defense team to hear testimony from witness former FBI Carrie Lando at a later date. Carrie L. flew to Arkansas from Illinois on Friday and was present at the hearing but did not take the stand. Spencer's defense team complained about excessive security in and around the courthouse. Several previous filings pushed Elmore to provide evidence of threats or risk that would make it that necessary. The attorney said they didn't want the heavy police presence to make the public or potential jurors get the idea that Spencer is dangerous. And that is fair. That is fair in this trial, in this situation. I can understand with that 100%. That is fair. 100% fair. Boo, that is fair. Just saying. Compared to the large number of officers in the area during the December pretrial hearing, few officers were around on Friday. During both hearings, several Arkansas State Police troopers were positioned in the courtroom as security. Okay, so now what I'd like to do, I do want to play this. Hold on.
Today. He's the dad on trial for killing the man who allegedly abused his daughter. THV 11's Tanya Motorzitsky was in the Lono County courtroom once again today. She brings us the latest.
Brooke and Faith, today's pretrial hearing centered around missing evidence that detectives admitted to losing. The focus during the last day of Aaron Spencer's pretrial hearing was not the gunfire or grief, but about what jurors may never get to see. Attorneys debate about dash cam footage from Michael Fossler's truck that no longer exists and who's responsible for that loss. During Thursday's hearing, it was discovered the lead detective on the investigation did not properly put the dash cam video of the incident into evidence within a timely manner. The investigator told attorneys he had it in his office, and it wasn't until a year later, just this past October, when the dash cam was properly submitted into evidence. Then earlier this month, the SD card for the dash cam was reported missing. The detective acknowledged the violation, telling the court he secured the card properly in the camera. Prosecution says the mistake on the detective's behalf was not in bad faith and there is not any Brady violation. While the defense says sound from the video would let us know what happened in real time. We caught up with Spencer's attorney, Aaron Casanelli, after pretrial.
It should shock the conscience of the court that that item of evidence has obvious, substantial value. I just can't imagine why it wasn't immediately preserved. And, you know, I think the testimony today was a lot of mistakes were made, and I can understand, I mean, we're all human, I understand mistakes, but once mistakes pile up to a certain degree, they're no longer mistakes.
The DA's office declined to give a comment, but Casanelli says they're preparing for trial and shared how Spencer is holding up.
You know, he's anxious. This is a terrible experience all the way around, and he's ready to get it over with. So we're looking forward to trial in January.
The judge did not make a ruling yet on if the missing dash cam footage can be used during trial. The judge said she'd have an answer for that after the holidays. Trial starts January 26, and you best believe THV 11 will be there bringing you updates every day.
Okay, so now I want to go over here. I have a couple of orders I want to show you. So let me do this, let me do this, let me do this, let me do this. I think it's this share. Biggin, fit width, fit the width. Okay, so let me see. January 26th. I'm looking at the dates here. 23rd. Okay, we're going to do this. All right. Now we have a formal order from the state of Arkansas Supreme Court. It has been ordered that, and let me put this back over into this, please. Thank you. It has been ordered that the session of the Supreme Court being and held on January 3rd was the following proceeding to wit. I can't scroll from the front. I got to do this. Petitioner's petition for writ of cert and other relief, emergency consideration requested, expedited consideration granted. Petition for writ of certiorari granted. Writ issued. Circuit Court, January 13, 2026. Order limiting courtroom occupancy and no recording vacated. They vacated it. It's yeeted. 23rd Judicial Court Judge Division, Honorable Barbara Elmore, removed from that case and all case related to it to be reassigned to a special circuit judge appointed by the court. Baker CJ and Hudson and Wood JJ would deny the petition for writ of Satori. So immediately staying the petition to this court to appoint a special judge has been given. Then we have this. Under the Section 13C, Amendment 80 Arkansas Constitution, a special judge may be assigned if the Chief Justice shall determine there is other need for a special judge to be temporarily appointed. Therefore, under the authority vested in the Chief Justice of the Supreme Court of Arkansas by Act 496 of 1965 as amended, and Ark Constitution Amendment 80, and because the Chief Justice has determined there is other need for a special judge to be appointed, Judge Ralph Wilson, bar number, retired circuit judge, is hereby assigned to the 23rd Judicial Court to hear the following case. State of Arkansas versus Aaron Spencer, Lone Oak County Circuit Court, case number 43CR24551. The assignment includes all ancillary proceedings which may arise in connection with said cause. Proceedings subsequent thereto shall be held at such time or times as shall be directed and ordered by Judge Wilson. This order made and entered on the 25th day of January 2026. Yes, and we have a new judge ordered. Let me get it playing. Get rid of all the commercials first. No, that's not what I wanted to happen. Well, I just lost it. Let me go back. Let me see if it'll back it up. Yeah, it will. No, it won't. Oh, there it is. Yeah, it is. I got to do all the commercials. Okay, let me get back and share the screen. So I want to thank everybody for joining, but most of all, I also want to thank everybody who has made comments in the past and our replays. I have thoroughly enjoyed watching them, and I've got a surprise for us in a minute. So I look forward to it did it again. Are you kidding me? Are you kidding me? It kicked me out again.
Liberal politicians in D.C. keep throwing curveballs to defeat President Trump's America First agenda. But Mark Teixeira.
Sorry about that. It kicked me out. Hold on.
Late news headlines we're following tonight.
Yeah, a new judge has been assigned to the Aaron Spencer murder
There
trial.
we go.
Retired Circuit Judge Ralph Wilson will now preside over the case after the Arkansas Supreme Court removed Circuit Judge Barbara Elmore on Friday for refusing to recuse herself. Spencer, the Lone Oak County Sheriff's candidate, has pleaded not guilty to second-degree murder in the shooting death of Michael Fossler, a man out on bond at the time for allegedly abusing Spencer's daughter in 2024. No new trial date has been set.
Okay, so what I need to find out is, give me a second. There has been some question about some of the so Aaron Spencer, that is where we are, and I think mods, do I need to do anything else? Catch me up while I'm waiting for the mods to see if there's anything else I need to share on this case, because I think I've done as best I can for tonight. I do want to show you this that just launched. It's sort of semi news. It is sort of semi as news. Let's go here. Listen to this, y'all. This, by the way, this is Henry Tenon seeks to withdraw guilty plea. It is breaking, sort of breaking news.
This was a planned and targeted ambush and murder. The ruthless homicide has pained our community.
Welcome back. In our spotlight, the man who pleaded guilty to killing Microsoft executive Jared Branigan says, never mind, and that he wants to go to trial. Henry Tenen pleaded guilty to Branigan's murder back in 2023. Branigan stopped his car because of a flat tire, because of a tire rather that was in the roadway. When he got out, he was ambushed, shot, and killed. His 2-year-old daughter was in the back seat. Now, Henry Tenen agreed to testify against his co-defendants, Mario Fernandez Saldana and Shanna Gardner, who's Branigan's ex. And both of them are accused of orchestrating this hit. Here's Tenen when he was arrested during a traffic stop.
I'm gonna put these on you. These are a lot more comfortable. Will you come take the dog?
Now, Henry Tenen's 3-page motion asking to withdraw his guilty plea says that he no longer wishes to testify against the estranged couple and wants to proceed to trial. A judge is going to be hearing arguments on this motion this morning. So what in the world could have happened to change this guy's mind? And what's the judge going to do? Is the judge going to allow him to withdraw that guilty plea? Let's break it all down. Let's bring in our legal eagles with me this morning, attorneys Dave Ehrenberg and Ben Chu. Good morning to you both. Dave, I'll start with you in Florida. Tell me, can he do this? Must the judge allow this? Go into professor mode for us, if you would kindly, please.
Julie, good to be with you. Well, the judge doesn't have to allow, but a lot of discretion is given to the defendant here. And we want to make sure he gets a fair trial, and he's going to be able to do this, I believe. And that's upsetting, of course, for the prosecution because he's a star witness. Then the question is, why would he do it? Perhaps it has something to do with his new lawyers who looked at the case and said, you got a better shot here just denying everything. You have Jose Baez on the other side who's probably encouraging and hoping this would happen. This is why they delayed this for so long, in the hope that he would change his mind. And he did. Also, remember, the death penalty in November of 2025 was taken off the table for Gardner and Fernandez. So maybe Tenen feels his leverage has shifted, or he's less to lose by rolling the dice at trial. A lot of reasons. Also, there's always the snitch factor. Maybe he doesn't want to look like he's a snitch and be in Florida prison.
Right, Dave. Yeah, all great possibilities there. Ben Chu, tell us what you think the motivation could have been for this sudden change.
Good morning, Julie. I agree wholeheartedly with Dave. I think he's absolutely right. I think Judge Kite will allow Mr. Tenen to change his plea. I also am right. I also believe he's right about the likely motivations that his new counsel, probably thinks this is his best way to go. I don't think that anybody got to him. I think it's more just a simple matter of his new counsel thinking that this is the best way for his client to go, rather than any outside pressure from the other defendants.
Sure. Should the state try to sweeten his deal somehow? Dave, what do you think? Do you think they're panicked with this?
No, and it's great to be on also with Ben. Thank you. I always love it when my co-panelist agrees with me. It's always better.
I only want the best of the best on this show, so that's why we invite you two on. Thanks for being here.
Thank you, Julie. Well,
Okay, so we're not going to keep watching that. I just want to let you know what was going on, that they did. Also, here's one other thing I want to show you. I know it's off topic because we're kind of done with that for the day, but these are things that I probably won't be able to get in tomorrow. But in the man accusing of killing Tupac, yeah, well, we have a hearing here. Here it is. Just quick. It's short. It's only 8 minutes. Don't worry. Half of it we're standing here.
That's a primary concern. I think a primary issue.
So let me jump forward then. I guess that's the sticking point.
This is an argument regarding a non-constitutional violation, so again, nighttime clause, which is a statutory construction. What authority is there that allows the court to suppress evidence for a non-constitutional violation under these circumstances?
Well, I think we can look at NRS 179.085 subsection D. It's our position that this warrant was illegally executed.
Sure.
And I believe that the statute, I mean, number one, this is a statutory animal, but number two, that statute allows for the suppression. The cases that were cited, both parties do converge on the point that if bad faith is involved, obviously that's the basis for the suppression. Well, and some has to include the evidentiary hearing if the court does not find bad faith based upon pleadings.
And so what would this evidentiary hearing look like that you're asking for?
We need to have Detective Mogg on the stand. It's our issue. It's not necessarily what was presented to the court, but what wasn't that constitutes the bad faith.
And so I guess evidence regarding his stability in the community that you've argued,
Correct.
Evidence regarding the age of his convictions, his age, things like that.
The fact that Detective Mogg had gone to his house and had a conversation with him. Also, the very fact that the justification for this nighttime search creates the very potential danger by executing the warrant at that time. That's our concern. And obviously, it may be difficult for the court to reach our conclusion absent an evidentiary hearing.
Understood. State, what's your position regarding the evidentiary hearing?
My position is there's no fact that they can establish before this court, which would result in you issuing an order of suppression. And here's why. And that's why in their reply, they take exception to our exhibits that we supplied to court. The suggestion is, well, if you told the magistrate he had survived cancer, she wouldn't have issued the nighttime clause. You and I both know that's not correct, but we also provided you, hey, the detective could have added more about his dangerousness as well. The fact that he makes the threat to Mike Tyson with the gun movement in videos around the time period that it happened. Their other argument is, oh, well, he only said he was arrested as an ex-felon. Well, it turns out he actually was convicted of possession of a firearm and received a 16-month sentence. There isn't any fact they could put before this court in an evidentiary hearing that would in any way change the analysis of the deference given to the judge. Is there any fact they could establish that a court wouldn't issue a nighttime clause? And look, you're a magistrate that signs these all the time. And their argument is that there's only 3 lines within this long affidavit that justifies the nighttime clause. And that's not the way you look at this. It's a holistic approach to this. You're talking about a homicide investigation involving very violent gangs. Yes, maybe 27 years old, but there's nothing in that 27 years that changes the analysis of whether or not a nighttime clause. Now they say they talked to Mr. Davis through, Detective Mogg talked to him through a steel door. What's relevant about that? Mr. Davis doesn't identify himself, denies being Mr. Davis. The fact that Detective Mogg knows it's Davis, but also he refuses to open a security door, and that's one of the things that he lists, that there's a security door that we may have to breach in order to get inside this house. What's relevant about that is more need for SWAT to execute the warrant. But here we have a situation where no magistrate would have ever denied a nighttime clause in this jurisdiction for a homicide suspect's house being searched by SWAT. That alone would have justified the clause, and it was her deference that you have to give the magistrate deference to suggest that they could prove any fact from anything that they've submitted to this court would change the analysis. It's just they haven't come up with any particular fact. They're saying Detective Mogg failed to provide certain information. Sure, in any affidavit, you can't describe every single fact that's true, but nothing that he failed to describe that they've raised would change the analysis or change the determination of the magistrate. So I suggest the motion should just be denied outright.
Okay, Mr. Draskovich, you sort of indicated that without a hearing, obviously getting to bad faith would be difficult for defense. Mr. Giacomo is saying there is no way to establish bad faith, even with what you're saying is, if what you're saying is necessarily true, that still doesn't get you there.
Well, there's reference made to the prior drug conviction, but then the fact that it's over 25 years old is omitted. What would you do with that? I mean, this idea of, for officer safety, the nighttime clause, and again, we're assuming, the issue concerning dangerousness is kind of a holistic approach. And what the detective chose to include and chose to exclude is indicative of a bad faith. We need to address that. In the large part, in the state's opposition, they supplement the record. So they're wanting the court to rely upon matters that were not contained within that affidavit. We're asking the court to do the same thing by way of an evidence hearing. We're talking to one witness.
Here, the defendant has not demonstrated that the magistrate abused their discretion in authorizing the nighttime service clause under NRS 179.0456D under Sanchez v. State, 103 Nevada 166, page 169 from 1987. The finding of reasonable necessity is reviewed for abuse of discretion in the affidavit provides a sufficient basis for the magistrate's good cause determination. When I look at the fact that this is a homicide investigation, there is the anticipated presence of the suspect with a prior violent felony and firearm history, as well as a steel door being present, which is not something common that officers necessarily encourage. The officer and public safety concerns do exist. The defendant's omission arguments do not establish a showing of intentional or reckless misconduct required under Franks versus Delaware. They also don't show that the inclusion of the omitted facts would have defeated the good cause finding. The warrant was executed pursuant to judicial authorization. There's no showing of bad faith, and such suppression is not warranted here. The motion is denied. States prepare the order.
Thank you.
All right. Regarding this as a status check trial readiness, my understanding is that there may be, we may need to readdress the court date, the trial date, but we do have a June 9th status check trial readiness. Do you want to do it at that time, or did you want to set a different date?
Let's do it earlier. I know that we had a discussion with all parties concerning potential dates close in time to current trial setting. Could we set this 2 weeks?
All right, we will vacate the 6/9/26 status check trial readiness and instead set it for a status check trial readiness in 2 weeks. That date will be
March 3rd at 9 a.m.
Okay, so that's an interesting twist. I don't know if in the Tumont case, I know we have followed that case, so we'll wait and see how it goes. We'll wait and see how all of it goes. So, guys, we have been on late tonight. It is now 7 o'clock. It'll be almost 12 hours that I've been on today, about 11 hours. My mods have been with me, so we are exhausted, but I thank you so much for staying with us. We will be live tomorrow again in the, gosh, what case are we following? Not the Faust. He was found guilty on all 9 counts in the, I'm pulling a brain cramp. I'm pulling a brain cramp, y'all. Colin Gray. Thank you. The Colin Gray trial. We will be live with that tomorrow. They say 7:30 in the morning my time. I'm not, if they start at 7:30 my time, I'm starting at 8. I'm not getting any sleep. So we'll be on by 8 o'clock in the morning my time, maybe 7:45. That's okay. I'm going to post it. If you click on the bell and you get the notifications, you'll know when I go on. Yay! You'll know when I go on. Thank you guys so much. And by the way, somebody made a question to me. Ada, why aren't you wearing eye makeup much anymore? Well, because I've been stressing over a lot of allergies and it's just, so I'm sorry to disappoint, but that's part of life. Again, thank you so much, mods. Let's go ahead and get our drawing underway, and then we can all go to sleep. Go to sleep. No, I haven't really had a meal today, so I'm going to go eat. Go eat. I'm going to eat me something bad. Okay. Yay! One more. I accidentally clicked the wrong button. Congratulations to the two winners. Thank you so much, Miss June and Miss Honey. Y'all have won the entries for the end of the month giveaway. It is showing my mod. So wonderful. Says they're showing 8:00 Central Standard Time. So I will be on at 8:00 in the morning. Come join us for the Cullen Gray trial. In the meantime, y'all have a fabulous evening. Get some rest and love on your family. And we'll do it all again tomorrow. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.